Respondent, my lord, I want inclusion of restoration application because
Lordships, kindly, my lord, order 41.
You are for the respondent. Give a
Respondent.
notice to the appellant.
Yeah.
Order 41.
Lordship, first appeal from a Matsu Lordship filed in the month
Which year?
2026 January. It was filed, Lordship. Lordship.
And it over. Up to 24? Fine.
My lord, I am mentioning one stay application in connection with the first.
Restoration application of a tribunal.
Stay application.
Please.
My lord, may I have your lordship's leave, my lord, to mention?
No, not now. Not now. First, the physical hearing. Yes.
Application today.
Not appearing.
Not appearing. This emergency, my lord, the bank is, my lord, proposing to confirm the sale of my stress loan exposure.
Supplementary 2 p.m. Supplementary. Please inform the other side. Yes.
My lord, order 41.
Look at it. Yes.
My lord, order 41.
Please.
Oh, this is simple. My lord, one more, my lord.
Application order 14, please. You need not mention. Please just hand over. Application order 14, please hand over without mention. Let us finish this, then we'll take up the other.
Let's stay, my lord, rising out of a tender.
Whenever the file comes, we'll put in the list.
Madam, sir, may I be permitted to mention FAT 241 of 2021? My lord, appeal admitted in 2021, my lord. And then it never got listed, my lord.
21.
21.
Application order 41, please mention, hand over the slips without mentioning. Yes.
Application.
What is the matter? Yes.
My lord, for admission.
If you mention, we won't take it. Thank you. Fine.
Sir, may I be permitted?
No further mention.
My lord, may I have your lordship's leave, my lord? My lord, I am happy.
Yes, you are there. Yes.
Yes, my lord, I was seeking an exemption, my lord. I was filing an appeal for a statutory authority, my lord. My lord, I was seeking an exemption from filing it online, my lord. My lord, because
No, we can't. No. Sorry, we can't do
because,
it.
my lord, there is an urgency.
No. We cannot disrupt the court procedure. Do it. Yes.
Number one is my.
I am for the appellant, my lord. But appellant number 1 has expired. My lord, 3rd February, my lord. After that, my lord, the eldest son, who is the Todbirkar, my lord, his mother-in-law also expired in June, because of which we could not file
application.
Kindly, my lord.
My lord,
With the
I
liberty, my lord, I'll
thought
file with
to file that application, but the department was not accepting on the ground that I do not have a Vokalatnama.
You have to have a Vokalatnama.
I am for the respondent.
respondent.
No,
I am
this is the office. We can't pass directions on this.
No,
I'll file. Kindly, my lord, adjourn for 2 weeks. I'll file in the
On the
mail.
not
prayer of
2
the
weeks, my
appellant,
lord. This is my
the matter is
appeal, for 2024.
on the
Partition
prayer of
to-
the appellants are permitted to file appropriate applications for substitution of the deceased parties. We should let the matter go out of the list with liberty to mention as and when the applications are filed.
Obliged.
Next.
Very extremely urgent.
No further mention.
Today, demolition, my lord.
Maybe. You are late.
Demolition,
You are late. Sorry.
my
No.
lord.
No.
My lord,
We cannot permit at any time. Sorry. No. These are court.
demolition is fast today, and
You should have come earlier, sir. You have not come. Sorry. Yes. Yes.
This came, my lord, for a limited purpose, my lord, by learned.
On that judgment.
Yes, even number of arbitrators. My lord, that is still the law. My
That
lord,
is
I-
still the law. Yes, we know.
Three things. My lord, 3 sentences, if my lords kindly permit me. My lord, the arbitration, my lord, took place at a point of time when the property was a trust property. So, my lord, Booz Island, no arbitration. Otherwise,
So
could
the
have.
other points remain. Your other arguments remain.
Yes. And my lord, there are decisions. I'm not troubling your lordship. If otherwise, my lord, the award is a nullity in any collateral or other proceeding, my lord can say.
So your other arguments remain, which Mr.
But
Lakman
my
has
lord,
also
Lohiya
answered.
is still.
My friend, my lord, has just urged one sentence. If I may just respond in 2 words.
No further.
Very
Grateful.
That's the law he has. Neen.
That's the law.
Grateful.
Thank you. Now. What we do? Oh. Okay. Now, since the hearing has already been concluded, no further order need be passed. The matter is reserved for judgment. Yes, next. Call.
My lord, I appear for the appellant, my lord. My lord, if your lordship sees my lord's last order, my lord, this would pertain, my lord, to a loan which the bank was supposed to disburse, my lord. The bank has written to us saying the loan is ready for disbursal. My lord, kindly seize
Yes, what
last
is it?
order.
yes, we are ready.
My lord, kindly gives us
We are ready.
a
We are
night's
also
time, because I'm told this week, my lord, 4 days the registration office might not work.
Borden will put the matter out of the list with liberty to you to mention. We'll put it as to be mentioned and pass final orders when it.
My lord, then kindly extends the interim order. Then it's the 31st of August.
But only one thing.
May I hand over the necessary documents required?
This arises from a specific performance, ma'am.
Yes.
Yes.
Performance, my lord.
You hand over documents to him.
Yes.
Yes, my lord, because I'm preparing the deed of
The
conveyance.
counsel for the appellant submits that the bank is agreeable to
No.
disburse the required loan for the purpose of having the appellant's part of the agreement in question performed. Push up. Learned counsel seeks a fortnight's adjournment for such purpose. Push up. Learned counsel for the respondent seeks to hand over certain relevant documents to the learned advocate for the appellants to facilitate mutual settlement between the parties by performance of the contract. Push up. Next para. Let the matter go out of the list with liberty to the parties to mention for inclusion in the list as and when the parties conclusively resolve the issue between themselves.
The interim order till 31st.
The interim order granted earlier is extended till September 30, 2026 or until further order, whichever is earlier, full stop. It is made clear that the parties are at liberty to perform their respective parts of the contract and have the dispute resolved between themselves.
I'm so grateful, my lord, so grateful.
Next.
This is my appeal, my lord. The lordship probably recalls, my lord, your lordship had heard this matter
Yes.
with the other bench on a Friday.
Oh, yes.
My lord, this is a very short point, my lord. My submissions were over. In fact, their submissions were also over, just except, my lord, on one point, Mr. Thakkar wanted to come back.
If you assure us that you can complete it in 20-30 minutes, then we'll put it on.
20-30 minutes is too long.
Not you, him.
We will not take more than 15 to 20.
Very
Right.
My lord, may I, then your lordship will hear it.
We'll just keep it as specially fixed matters on next Thursday on the hearing day.
The only difficulty is, my lord, 28th is the, again, my lord, it will be automatically extended before the court
It's
will, my
Friday.
lord.
27th, you are keeping it
Very
as
good.
special fix. The matter
Lord,
be placed in the
Only, Lord, I'm
list
sorry.
on August 27, 2026 under the heading special fixed matters.
Lord,
For
28th,
hearing.
my learned advocate on record has 27th, my learned advocate on record has some.
Okay, we make some arrangement. Yes. Next.
Specially fixed matters, your lordship will take up on that day at
Yes.
the top, my lord.
27.
27.
Special fix is a new name for part heard before the previous ones.
Well, we are
And actually, we'll argue because Justice Day was not there.
Yes,
Yes.
but I have to.
10 minutes for you, 15 minutes for
Yes,
him,
yes.
5 for you in rejoinder.
Yes.
It's okay.
But unfortunately, on the last day, Pathard came very low down the list. That is the difficulty, my lord. If your lordship kindly.
Special fix there, she doesn't have any option to put it low.
But otherwise, I will have to disturb and mention again, my lord.
Please do disturb.
Okay.
It happens so.
Okay.
Yes, Mr. Party.
What
What is your nature of disturbance of the disturbance to the court?
Mala, it is Mala, we are Mala just running pillar from post for 29 years to get one record.
Who among us is the pillar and who is the post?
Mala, that is Mala, the Mala retained land
What is
was.
the matter, Mr. Party? Let us come to the point.
Yes. My state will
Don't
come
have
to
much
Mala.
time, so make it short.
It is Mala. I am not going to the Mala entire case. Your lordship
No,
kindly
just
come to Mala
touch the case, Mr. Pahari, because my brother was not there.
Mile.
So you just touch the matter.
Mile.
What are the merits of the matter? Just touch it.
My lord.
What is the dispute about?
Dispute about, my lord, it is, my lord, I filed application before the land challenging the order of the revenue officer.
What was the order?
With, well, it is, my lord, regent order was passed.
Order under on which application? What was the context of the matter?
Man, it is, my lord, original application was filed against the order passed by the revenue officer before
Order
the
of the
tribunal.
revenue officer was passed under which provision of law, Mr. Pahari?
No, there is no such provision. It is, my lord, miscase.
What was the application for which you disposed of by the revenue officer?
Yes, it is, my lord, application is this. My retained land was, my lord, to allocate to us, and thereafter RS record was given. Subsequently,
Record correction.
correction.
They applied or you applied?
I applied.
You applied, that was rejected or allowed?
That was not rejected. They said that in this stage, that two
They means
appeals is
who
pending.
is they?
Well, that is my revenue officer.
Revenue officer.
Revenue officer said it is not possible to pass this order at this stage
Why?
as two appeal is pending.
Appeal against?
Appeal against the order of the earlier revenue officer.
And what was that, please?
This is when this order was set aside. By your lordship. The
Understand why you set it aside, but please give us a context of what was the earlier order about.
Earlier order, it is, my lord, the.
Mr. Parry, we don't have to ask you questions, please.
My lord,
Give the nutshell, the facts of the case in a nutshell. What happened
Not-
previously?
Yes.
We
My lord,
have
what
to ask
happened-
you every time when you.
What happened previously, my lord? In the year 1997, my lord, the revenue officer allowed to retain, my lord, prescribed selling of land.
Which act?
My lord, under West Bengal State Acquisition,
Very well. Then
25 acres of land was given.
section 6.
Yes. Additionally, against this order, my lord, no appeal was referred. This order came to its finality. And subsequently, my lord, RS record was, my lord, made. Where, my lord, there is no, my lord, vesting has been, my lord,
Fine.
recorded.
Then
And therefore, we said that the as my lord allotment of my 25 acres of land already given. So I am praying to my lord corresponding LR record, which was already, my lord, recorded. RS record was,
Fine.
it was
Yes.
given to me.
Then
And that stage, my lord, it was denied, and I filed, my lord, application before the Honorable Tribunal.
no, you said
Yes.
that there's a previous appeal against what?
No, I am coming. That is, my lord, it is my case. Well, it another case, my lord, the appeal was preferred.
That case arose from what?
But that is, my lord, BR case. 4 kinds of BR case was studied. 4 numbers of BR cases. I am one
We're
of
not
the
interested in the numbers. What was the matter about? The previous matters against which appeal was preferred.
That is, my lord, 6-1 proceedings. Your lordship kindly get it, my lord. Your lordship kindly get it. That is, my lord, I am.
You have to look at the papers, Mr. Parry. You fail in your duty as an advocate.
My lord, what happened, my lord, in this case? My lord, I am, my lord, here. That, my lord, the allotted.
You went to the tribunal, then what happened?
Tribunal, my lord, I went to the tribunal. That is an order passed by the revenue officer who refused to correct the record of rights on the ground. 2 other appeals is pending in the, my lord, against, my lord, other intermediaries, not against us. So, my lord, it is, my lord, this order was passed. The appeal was preferred.
Let us see
And
the order.
I made-
Let us see the impugned order first.
My lord. And your lordship kindly see page 111.
111. What is that?
That is my dispute here. This is, my lord, this application condonation of delay was, my lord, made, and condonation of delay was allowed, and thereafter, my lord, hearing was fixed on merit. And after 2 years, when the judge was retired, then, my lord, they filed a review application. So I say that review application is not maintainable.
They filed a review application against allowing your condonation.
No, it is, my lord. Yes. That is, my lord, 111. Your lordship kindly see.
No, yes. There's a difference between
That
the
is,
two.
my lord, that is 111. That is, my lord, review. That is application of condonation of delay.
Application was an order allowing your application for condonation of delay. They filed a review against that.
Yes.
That has been allowed now, against which you have come up.
Yes.
So I go into the facts of the case. Let us see the impugned order first.
Your lordship kindly impugned order get it, my lord. $178. $178.
ছিল না অন্য ছিল বলছে কেন এরাও রেকর্ডিং বলছে কেন that বিষয়ে you must. You did not file a section 5 application.
Yes. I filed section application, but section 5 application is there.
Understand the logic of this order.
And it was, my lord, they said, the tribunal said, it is not needed. As well, it is, my lord, very short point, very short time, 150 days. And from the date of passing this order, Well, this was pending before this Honorable High Court.
No, the
So their
application was rejected.
petition was not maintainable. It is
Why
your
not
lordship
maintainable?
kindly get it 111.
This was their review application or your review application?
No, it's their review application. So, my lord, he said that the application for condemnation of delay is not maintainable
In the previous order.
previous order, and that's why, my lord, he said that it is to be decided on merit. Your lordship kindly get it 114. The date of fixed for hearing.
Now he says no, that review application is, that condonation application is maintainable. So now he wants to hear it on merits.
On merit.
He's right in saying that.
No, I
Condonation application
started.
is maintainable. Your application for condonation was rejected on the ground it is not required. Now he reviews that order. He says no, it's required. I'll hear it on merits. What's the wrong in this?
Yes, ma'am.
Argue it on merits, Mr. Party.
Yes, my lord. It is wrong in this order, my lord. That is, my lord, the order cannot be redundant. Order cannot be, my lord, reviewed.
Why?
My lord, but it is, my lord. I am.
Tribunal doesn't have the power to review. That's why.
I am just giving, my lord, just judgment of the Supreme Court.
No, you alleged inaction. Inaction of the
Inaction. It is, my lord, stated inaction. That no reason to order was passed.
What was the nature of inaction?
Nature of election, my lord, I made representation to correct the record of rights in terms of the order passed by the RS. Condolence. They said that the two appeals, another appeal is pending. So it is not possible for him to pass any order.
What was the reason for the delay?
Reason for delay, my lord, it is pending before this, my lord, Honorable High Court.
What is pending?
What is pending, my lord? The stipulated time was given to the revenue officer. Within certain times, my lord, they should directed to dispose of this matter. In this meantime, they did not dispose of. I filed contempt application. So during that time, my lord, the contempt application was filed. And so this was the reason only. And my lord, after disposal of the, my lord, at the time of the hearing, that is, my lord, the delay was caused. So therefore, I immediately filed my lord application on 6/1. That is my 299.
Hard on merits, you succeed there.
Yes, I am only praying.
I
am only praying. I am go back to there to hear it on merits.
That is the order passed.
No, it is my lord, the review application.
All
It
the
was
foregoing reasons are considered.
review application. It was, my lord, rejected. This order. This order was recalled.
Impugned, please.
Huh.
Please come to page 182.
182. Yes. 182.
See the last paragraph.
Hmm.
The impugned order judgment is hereby recalled. Both parties are directed to come ready for hearing on the date fixed on the application for condonation of delay.
Yes. On the application.
Argue it on merits.
No, hard on. It is, my lord, application. I am here. That is, my lord, when the matter was, my lord, hearing was started on merit. And at the time of after 2 years, he made application. Well, your lordship
application was made after 2 years.
Yes. Your lordship kindly see that it was, my lord, it was fixed. I present there. Hear out this matter on merit. And hearing was started. Pathar was made. Thereafter, after 2 years, my lord, they said that no, hearing would not be possible. So it to be reheard once again. That is, my lord, section 5. That's why, my lord, trouble comes. Your lordship kindly come to, my lord. Yes. 115, your lordship kindly come. 115. Let the matter appear in the list of hearing. And thereafter, my lord, your lordship kindly 116. I started hearing. It is Pathar. I started hearing on merit. It is Pathar. 116. Then 117. Continuous, my lord, we are, my lord, attending the hearing and, my lord, the Pathar on merit. So at this stage, my lord, I am praying after 2 years when the judge changed.
My lord, only thing that when this we filed an application for condonation of delay in connection with the review application.
You filed?
Yes, my lord. My lord, this my lord on my lord kindly sees page 1.
You did not file the condonation application.
I filed condonation application. It was
to file the condonation application.
May I submit?
Condonation application I filed.
My lord, in
And
connection
it was,
You filed the review application.
review application.
yes,
And
saying you filed the condonation application.
I filed a condonation of delay application in connection with the review application
Review
because it was filed after 705 days. My lord, the applicant did not raise any objection. My lord. My lord, the-
Carry on.
my lord,
Complete
this,
the sentence.
yes, my lord, order specifically records that he raises no objection in allowing the application for condonation of delay. My lord, may kindly comes to page 170.
Allowing the application for condonation of delay in the review application.
Yes,
No, but why should
no,
the
no, no,
review-
section 5, but you filed section of
Take your seat,
my,
Mr. Parikh.
my,
Take your seat. You have a seat behind you. Please take
my,
your seat.
my lord, may I place the order? Well, may I place the order?
Wait. First, we want to make Mr. Pahari sit. Take your seat.
my,
The review application is maintainable under which provision?
Well, let's kindly see section 16 of the
Section?
section 16
Yes, of the
of the West
Electricity
Bengal
Act.
Land Reform Tenancy Tribunal
yes.
Act 1997. Section 16 D.
Reviewing. What is the ground for condonation of delay in the review?
My lord,
You say they gave consent to that.
yes, no.
Review, what is the ground
even
for
after
review?
that,
Very
even
well,
after
understood.
that, my
The
lord,
condonation. What is the ground for review?
my lord,
You say that limitation is applicable.
yes, because my lord, that the applicant
Please come
has,
to section 10 of the Act,
Mine.
Electricity Act. What is the language? Order or action.
yes, my lord,
You see inaction is included in that.
inaction, but he has not challenged the inaction, but an order. My lord, may kindly sees this page 111, the order which has earlier referred by my lord,
Let's see that. Yes.
this OA has been filed by the applicant challenging the order passed by the SRO and BLLRO Sutahata 1 District Purbo
Oh.
Medinipur dated 8th August
It's
2000.
not an inaction.
No, it is not an inaction, my lord. So, my lord, the period of limitation prescribed under the Act applies.
Yes. And where is the consent recorded? Impugn
My
order?
lord, may kindly comes to 178, the bottom line, my lord. At the outset of hearing, learned counsel for the applicants, hearing respondents raised no objection in allowing the application for condonation of delay, as the main thrust was on the review application. Be that as it may, on perusal of MA 742/2025, we find that length of delay of 705 days, and this delay was occurred due to various paraphernalia and activism of the statement, which has sufficiently been expressed.
Yes, you want to
by
add
Section
anything?
29. No. My
Yes. What is your?
my lord,
Yes. We take that as the argument of the Bhattacharya.
my, your lordship kindly see the ground of review. My lord, it is my lord, hearing was made on
It's
review
about two
application.
things. One is that you consider to the condonation application regarding the review. The first order, 111, it records clearly that you have challenged an order. So it was a palpable error of the tribunal. So tribunal reviewed it and wants to hear the condonation application in the main application on merits.
My lord, it is.
Why should you interfere here?
Yes, yes. My lord, it is my
You are making a fuss
contention.
about nothing. Your
No,
client.
my contention is this. My lord, the review, that is my lord, the condonation of delay. He is, my lord, saying that the section 5 of condonation of delay. Section 5 is missing from the, my lord, the statute. Section, there is no provision of section 5. So it is the story of section 5. Here is absolutely illegal. Well, it is, my lordship kindly see.
If there is no provision, there is no bar in a statute, section 5 applies by default.
Any, my lord, that is, my lord, if any delay is made, it is, my lord,
Limitation Act.
discretionary power.
Anandita, Limitation
Yes.
Act.
Any, your lordship kindly see. 6 and 10-2, Your Lordship, kindly. And it was been decided by this honorable court that it is, my lord, section 5 is not applicable.
Please come to section 29(2) of the
20.
limitation. And you filed a section 5 application. You are now saying it's not meant.
No. I am not filing, my lord,
In the original application.
original application for condonation of delay only.
So
Your
section
Lordship,
5
I
is a
am
wrong
saying-
caption. Let us forget it. Condonation application you filed. Now you are saying it's not maintainable.
No.
Section
I
5 is not
section
applicable.
5.
When will we say it's a wrong quotation of section, but the condonation application still lies and the order is correct?
Yes. My condonation
That
application.
is-
Condonation application is, my lord, made. If it is, my lord, discretionary power of the court, just to, my lord, delay the condon. It is specifically stated. Section
Mr.
10(2).
Bahari, you are just making a fuss about nothing. Initially, the tribunal said your original application is an application complaining of inaction. That's why section 5 is not maintainable. Subsequently, they pointed out, and you considered to their condonation application in the review. So in the review, they point out that no, you have challenged a specific order, not an inaction. Therefore, limitation is maintainable. Tribunal held it's an error apparent on the face of record. That's why I am recalling that I am hearing the condonation application on merit.
My lord, your lordship, kindly see, it is not the, my lord.
Not the minor means?
It is, my lord, that is, my lord.
This
He has
cannot be
explained
minor,
it.
but this is
He has
absolute.
explained it. So why it is not maintainable? He has explained it. Your lordship, kindly see. 111. I am placing it.
Yes, he has explained. We have seen the explanation. Explanation is at page 113.
Yes, one. He explanation
seen it,
wrong. Iruna
underlined it in red
No, I am.
on the previous
My
option.
lord, your lordship, just bear me for a moment. Well, I am, my
But
lord.
we won't bear you for a moment.
No, I am saying that, my lord,
The
it
burning
is
submission.
before your lordship. It is before your lordship.
It's before
The
us.
condonation of delay is not, my lord, subject matter of this case. Condonation of delay is, my lord, only connected application only for hear out this case. Condonation of delay, for the condonation of delay, again, my lord, it will, my lord, your lordship, kindly see, 19, my lord, I filed application.
Your OA was delayed beyond the stipulated period of 60 days probably.
60 days.
60 days. You have challenged an order. You filed a condonation application. Tribunal said, no, condonation is not required because you are challenging an inaction.
No. It
What?
has
No,
not
no,
been
no,
said.
please come
It
to
has
page
not-
1.
your lordship,
Mr. Bal,
kindly-
please.
lordship,
Waste
kindly-
time of the court, please.
No, your
We-
lordship,
we're very
your
impatient
lordship,
on this.
kindly, that is, my lord, the appeal, that is, my lord, if appeal is pending before that DLRO,
Please come to
then-
page 113, please.
my lord,
Take the trouble of reading the last
I am,
paragraph.
I am just, maybe I am wrong. Your lordship,
Wasting time.
112.
Mr. Bahari will impose costs on your client. Please come
Well-
to page 11. No, please come to the last paragraph of 113. You
112.
will understand why we will impose costs.
No, he, my lord, when he said,
Come to 113.
112.
Last paragraph. Please read it.
At the time of application is maintainable for the tribunal alleging inaction on part of the revenue authority.
You are reading
But
as
there
if
is-
you don't understand. At the same time, an application is maintainable before the tribunal alleging inaction on the part of the revenue authority, but there is no limitation for making such application alleging such inaction.
My lord,
On this premise, accordingly, section 5 is not applicable.
my lord.
And the section 5 was disposed of as not maintainable.
Then, my
But
lord, your-
when tribunal understood this, then what?
but when any matter is disposed of, it cannot be treated as inaction on part of the revenue
Yes.
authority. According, it should be bound to come under the purview of the appeal, for which there must be some prescribed provisions as well as the period of limitation.
This was also error
In the-
apparent on the face of record. This was also error apparent on the face of record.
If I may really allow me to, my lord, place the judgment.
Hold করেছে।
I am just only, my lord, your lordship, kindly come to, my lord, 1997.
Oh, your cited a judgment. Very good. We'd love to see that.
My, it is for my sake.
No. We
If,
will
my
also
lord,
be satisfied with-
Irunas
We
order,
love judgments. Please cite.
Irunas order cannot be, my lord, set aside by review.
Erroneous order cannot be set aside by review.
Why? It is, my
This is
lord,
an error apparent on the face of the record. So apparent that it strikes the conscience.
that, my lord, it is, my lord, face of the record, my lord, they said, my lord, I am saying it is the merit.
We are not saying that. We don't agree. Our view prevails. Please cite the judgment quickly and we'll pass it.
Well, 17-2 and my lord another judgment.
Per judgment 1,000 rupees.
My lord, it is my satisfaction, my lord, your lordship.
No, we are just joking.
Yes, lordship, kindly. My lord, we are suffering for 29 years, my lord.
We understand the
29
reason now.
No, my lord.
We understand the reason
My
now.
lord, my lord.
Which page of the
Second-
second judgment? First
That's
judgment
my
you
lord,
have seen
the
here.
first judgment, sir. First judgment.
First
my
judgment you have seen here marked.
That is-
Which paragraph of the second
Which-
judgment?
Yes, second judgment, my lord, that is
Yes, para
Same.
17.2. Fine.
20. So I said, my lord, it is not.
Yes.
My
The
lord,
present application has been, the present
Madam,
challenge has been preferred against.
my lord, may I one, mainly one. My lord, your lordship, kindly, I am only praying before your lordship. My lord, here, my lord, we are all here. So the condonation of delay petition is with me. So my lord, condonation of delay may be, my lord, made before by your lordship, and so that the hearing can be made. So that, my lord,
Present challenge has
just-
been preferred against an order whereby the learned tribunal reviewed its earlier order dated September 28, 2022, whereby the learned tribunal had held that an application under section 5 of the Limitation Act, for condonation of delay in filing an original application by the writ petitioner was redundant. Full stop. Next para. In the said order dated September 28, 2022, the learned tribunal had recorded that an application is maintainable before the tribunal alleging inaction on the part of any revenue authority, but there is no limitation for making such application alleging inaction. Push up. The learned tribunal further held that when any matter is disposed of, it cannot be treated as inaction on the part of the revenue authority, and accordingly, it should be bound to come under the purview of double inverted appeal, inverted clause, for which there must be some prescribed provision as well as period of limitation. Which of the learned tribunal, at such instance, further held that as there is no prescribed period for filing appeal before the tribunal against the order passed by the revenue authority below the rank of collector, the said condonation application was not maintainable. Which of next para. Learned counsel for the appellant argues that the review application was filed belatedly. Furthermore, it is contended that Section 5 of the Limitation Act is not applicable per se to an application before the tribunal. Next para. It is further submitted, by placing reliance on such and such reported at 1997 8 SCC 715 as well as such and such reported at 2025 SCC online SC 1927, that the scope of review is limited, and even if there is an error which has to be established by a long drawn process of reasoning on points, review under order 47 of the Code of Civil Procedure or principles akin thereto is not maintainable. Next para. It is submitted that there was no error apparent on the face of the record, and as such, the review application ought to have been dismissed. Lastly, learned counsel submits that in the event this court holds on such count against the writ petitioners, this court may consider the condonation application on merits and allow the same. Next para. Learned senior standing counsel appearing for the state opposes the prayer and submits that an application for review is well maintainable before the tribunal under section 16 of the West Bengal Land Reforms and Tenancy Tribunal Act 1997. It is further pointed out that in the impugned order itself, it was recorded by the learned tribunal that the writ petitioner had conceded to the had conceded to the prayer for condonation of delay in filing the review application, and as such, cannot reopen the condonation of such delay now. Next para. Secondly, it is argued that the initial order of the tribunal was fraught FRAUGHT with patent error, and as such, it came within the purview of the principles under Order 47 of the Code of Civil Procedure. Full stop. Next para. Upon a consideration of the order dated September 28, 2022, we find that the learned tribunal was justified in holding that there was error apparent on the face of the record. Full stop. Whereas an application before the tribunal lies within the contours of Section 10 of the 1997 Act, read with Section 6 thereof, the same cannot per se be couched as an appeal, if the appeal is otherwise not maintainable before the tribunal but before an appellate authority. Full stop. In the present case, the original application was filed by way of a tribunal application within the purview of Section 6 and 10 of the 1997 Act and not as an appeal, for the simple reason that a statutory appeal does not lie against the order of the revenue officer before the tribunal. Full stop. Irrespective of what outcome the such application will meet at the end of the adjudication, fact remains that the application was not an within double inverted appeal within the contemplation of any statute. Full stop. Next para. Thus, the learned tribunal was justified in recording in the present impugned order that it had committed an error apparent on the face of the record by holding that the condonation application in respect of the original application was not maintainable. Full stop. Next para. Even otherwise, since the original application is not against an inaction but an order passed by the revenue officer, the learned tribunal was justified in holding that the the original order was suffered from an error apparent on the face of record. Full stop. Insofar as the delay in filing the review application is concerned, learned senior standing counsel is justified in arguing that the present writ petitioners themselves had conceded to the condonation application and as such the said chapter cannot be reopened. Full stop. In view of the aforesaid findings, we are of the opinion that the learned tribunal was justified in passing the impugned order. Full stop. Hence, WPLRT 22 of 2026 is insofar as the argument that the Section 5 that the condonation application should be disposed of on merits by this court, we are loath without E in doing so, since the adjudication of the condonation application of merits by this court will rob ROB, the parties, from a forum of challenge. Full stop. Hence, we are not inclined to usurp the jurisdiction of the learned tribunal by deciding the said condonation application before this court. Full stop. Next para. Accordingly, WP LRT number 22 of 2026 is dismissed on contest, thereby affirming the impugned order dated December 24, 2025, passed by the second bench, West Bengal Land Reforms and Tenancy Tribunal in MA 7. This was MA 1162 or 7? Passed in MA 1162/2024 and MA 742 of 2025 within bracket LRTT, filed in connection with OA 56 of 2019. Full stop. Next para. In view of the delay involved, we request the learned tribunal to dispose of the condonation application pursuant to the impugned order as expeditiously as possible on merits, preferably within 1 month from the date of communication of this order to the tribunal. No rest to cause urgent certificate. আচ্ছা একটা লাইন অ্যাড করে দেবেন আগে কোথাও একটা ওই লাস্ট মানে যে কনক্লুশনের আগে insofar as the cited judgments are concerned, there is no dispute with the proposition that the scope of review is limited, full stop. However, since we have observed that the impugned order suffers from error apparent on the face of the record, the ratio laid down in the said judgments are not applicable to this case. Thank you. Next. Yes.
My lord, I beg to appear on behalf of the private list.
What is the matter, please?
My lord, the present petition.
Push him, push him, push him.
My lord, this present petition, my lord,
Yes.
against the judgment dated my lord, September 26, 2025, my lord.
That much we know. What is the matter about?
Matter, my lord, the petitioner filed an application for deposit of rent before additional rent control Barakpur for the period of December 19 to January 2023. The petition was allowed. Pursuant to the said order, petitioner deposit the rent. Challenging the said order, my lord, the respondent of 5 hearing filed an original application, my lord, alleging that the order passed by the rent controller suffers from the non-joinder of necessary parties and not passed in consonance with the section 21-22 of the West Bengal Premises and Tenancy Act.
Non-joiner of the landlord.
Landlord, my lord. My lord, this is not landlord, my lord. Only one against the one landlord the petition was filed. There are more than one landlord as per their my lord version. My lord, second, this honorable tribunal remanded back the petition to the rent controller to fresh adjudication. My lord, the problem is that my lord kindly see the page number 28. Now, the tenant cell, the deposit of rent. We are concerned about the deposit of rent. That deposit of rent, if already made by the respondent, number 2 tenant, shall not be treated as a valid deposit, my lord. My concern is that this person is, my lord, affects the merits of the fresh case. I put question on myself. If I succeed again, what will be the fate of this deposit?
So you will be satisfied before going to your other side. He's entitled to his arguments. Would you be satisfied if you hold that the validity of the deposits will be kept open subject to the
My
fresh
lord, that in the
Both
definition.
sides are happy, we are also happy. The present challenge has been preferred against an order whereby the learned tribunal remanded an application for deposit of rent by the alleged tenant, that is the writ petitioners, under sections 21 and 22 of the West Bengal Premises Tenancy Act 1997. Whose next para learned counsel for the writ petitioner argues that while doing so, the learned tribunal observed that the deposits made by the petitioner shall not be treated as valid deposit, which would tantamount to prejudging the issue of the validity of the deposits, which is bad in law in the teeth of the remand order. Next para, heard learned counsel for the parties, it transpires that in view of the tribunal having remanded the matter to the additional rent controller for a fresh adjudication on merits on the application under sections 21 and 22 of the 1997 Act, it would be premature to observe simultaneously that the deposits made by the writ petitioner shall not be treated as valid deposit. Next para. Accordingly, WP LRT 62 of 2026 is partially allowed, thereby modifying the impugned order dated September 26, 2025, passed by the 4th bench of the West Bengal Land Reforms and Tenancy Tribunal, to the limited extent that the observation within double inverted, the deposit of rent, if already made by respondent number 2 stroke tenant, shall not be treated as valid deposit, inverted close, is treated to be expunged from the said order. It is made clear that the validity of the deposits so made by the writ petitioner shall be subject to the outcome of the fresh adjudication of the application under sections 21 and 22 of the 1997 Act on merits. We make it abundantly clear that this court has not entered into the merits of the case, and it will be open to both parties to raise all their contentions before the tribunal in the fresh adjudication. No other orders to cause.
Great.
Thank you so much. Yes. And thank you for being reasonable. লাস্টে বোধহয় ট্রাইব্যুনাল বলছে ওটা অ্যাডিশনাল রেন্ট কন্ট্রোল দেখে নেবেন একটু মিনিংলেস হলে
statute also mind that there is no provision for refund the rent to the tenant.
your presence is noted. Yes.
I beg to appear on behalf of the petitioner, my lord. In terms of my lord's last order, my lord, we have filed an application for substitution, my lord, substituting the respondent number 13 and 17.
You are for the petitioner?
Yes, my lord.
You have filed it.
Yes.
It's appearing before us.
Yes, yes, it is appearing to me. As I was, my lord, submitting that this is, my lord, an application is with an innocuous prayer for expeditious hearing before the tribunal. my
Yes, what about this?
On account of the
For the private respondent.
I'm
I'm
for
for
the
the
state,
private
Your
list.
Lordship. I'm for
State private is very. So you are also. You are agreeing?
Regarding expedition or in one application.
No, 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 no. Means we are asking you. You are agreeing. You say no, no, no.
Upon the
You are
date.
not agreeing to the expeditious hearing.
Yes, I am agreeing.
Then why do you say no, no, no?
Well, in respect of this, can one, well,
Yes.
upon the death of two parties, one application filed. Well,
Yeah.
this.
well, it's mere technicality.
And well, only one thing, well,
He has answered you. Yes, what else?
we have not yet filed an affidavit in opposition.
Yes,
that
No, no,
required.
we'll say.
The next date, my lord, is fixed on 12th of
12th
November.
November.
Kindly direct.
Sorry?
12th November is the
12th,
next
Yes, before the tribunal.
Right. Can 1 of 2026 is an application for substitution of the heirs and legal representatives of which respondents?
13 and 17, my lord.
Of respondent numbers 13 and 17. First of next para, learned counsel appearing for the private respondent submits contents that a single application has been made for substitution of two respondents, comma, and as such the application is not maintainable. Full stop. However, comma, we are unable to accept such contention of the private respondent, comma, since the objection is premised on mere hypertechnicality. Full stop. Next para. On a perusal of the application, comma, we find sufficient explanation having been given. Full stop. Accordingly, can 1 of 2026 is allowed on contest, comma, thereby directing the heirs and legal representatives of respondent number 13, namely Supriya Das, within brackets since deceased, to be expunged, and the heirs of respondent number 17, namely Anil Chandra Roy, alias Olin, ALIN, Chandra Roy, comma, bracket since deceased, bracket closed, to be substituted by his heirs and legal representatives as mentioned in the prayer portion of the application as respondent numbers 17A, 17B, 17C and 17D, sub capital A, respectively. Full stop. The learned advocate on record for the writ petitioner shall carry out the necessary corrections accordingly to the cause title of the writ petition during the course of the day. Full stop. Next para. Insofar as the writ petition is concerned, comma, the innocuous prayer of the writ petitioner is for expeditious hearing of the original application filed before the tribunal. Full stop. We find from the order dated March 12, 2026, comma, that the matter has next been fixed on November 12, 2026. Full stop. Next para. Upon a consideration of the matter, comma, we find that the original application is pending since 2024, and for the ends of justice, comma, the matter is required to be expedited. Full stop. Accordingly, WP LRT 122 of 2026 is disposed of by requesting the first bench of the West Bengal Land Reforms and Tenancy Tribunal to dispose of OA 253 of 2024 within bracket LRTT as expeditiously as possible, comma, preferably within 6 months, by taking it up for hearing on the next date fixed, that is on November 12, 2026, and conclusively disposing of the same within the period as indicated above. Full stop. Next para. No orders to cause urgent certificate. 6 months from that date.
In the meantime, the affidavit, we are not using the affidavit in
Since we have not invited any affidavits, it is deemed that none of the allegations made in the writ petition are admitted by any of the respondents.
Before the land tribunal, we have
Here
to
also,
file
Your Lordship, the pleadings are not complete. So,
That
in the
pleadings
meantime,
not.
Yes, thank you. একটা লাইন যেখানে ডিসপোজ অফ বললাম তার ঠিক আগে the is it called an affidavit in opposition before the tribunal or a written objection?
Affidavit in opposition.
The respondents will be at the respondents shall file their respective affidavits in opposition, comma, if any, comma, to the original application within 3 weeks from date. Yes.
The order passed by the tribunal
Yes.
is a big one. Before going into that, my lord, I am just telling your lordship in brief the facts of this case. My lord, the petitioner
Yes.
purchased not less 4.784 acres of land in 1962 from the erstwhile recorded owners. My lord, in the CS records of right or in the RS records of right, he was recorded as Dakholkar. In most of the lands, Dakholkar, and in my lord, some small portion of land as Lakhiraj and Malik. These are the three recordings. Now, my lord, in the both in the RS and in the LR records of right, which was issued sometimes in 2013, name of the petitioner was wrongly recorded. He was possibly, my lord, the confirming party. He is removed. That is not much disputed here. Now, my lord, just a minute. Now, my lord, ultimately, in 2013, the petitioner applied for correction of records of right in the LR records of right. Now, my lord, his name was recorded. LR records of that we have all annexed, my lord, before going to that. I am just telling you to cut short the matter. Now, LR records of right were issued. Now, that was a clean. Only the name of the petitioner as recorded in the that was the record, and but there was no endorsement in the remarks column that subject to 6(3) proceedings of the West Bengal Estate Acquisition Act. That was not there. Now, it may be mistake. I am admitting whatever may be that. Now, Lord, then, my lord, in 2017 or like that, the petitioner applied for conversion a portion of the land measuring about 2 point something acres. Out of that, my lord, that was allowed. Then, my lord, they again applied for correction of records of right. Then, my lord, again, my lord, the LR records of right were issued, and my lord, therein, my lord, also, my lord, the after conversion, that conversion was recorded, my lord, not classified properly in the LR records of right. My lord, that prompted them to file another application for correction of records of right. Ultimately, my lord, while these things are going on, the government, the Land and Land Reforms Department, they said that you are to take lease under Section 4B2 of the Land Reforms Act. Then, my lord, we again applied. Conversion order was issued, but conversion order was not recorded in the LR records of right that was issued. Number ultimately demand of justice was made.
No, Section 4B2.
4B2.
All.
4B2. But that will be not relevant because this is a, I am telling your lordship, this is a second round of litigation. When, my lord, initially, so far as the correction of application for correction of records of rights are concerned, that was, my lord, delegated to the concerned block land and land officer. That was challenged by the petitioner before your lordships. Then, my lord, your lordship set aside that order, and, my lord, remanded the back to the Land Reforms Tribunal for decided its merit. You decided whether correction of records of rights should be made or not. This was the factual, but while remitted the remanded the matter back to your lordships clearly hold that 4B2 has no manner of application. That will come later on. For your lordships has quashed that portion, but so far as the other portion, correction of records of right, and another one thing, your lordships gave liberty to the Land Reforms Tribunal to decide whether the order of conversion was passed without jurisdiction or not. If it is without jurisdiction, your lordships gave liberty to the tribunal to set aside this order. Now, my lord, ultimately, what has been held by the tribunal, I to show to your lordship, ultimately, tribunal has held that our primary contention on the basis of this, that since it was recorded the Dakholkar, we are non-agricultural tenant. And non-agricultural tenant doesn't vest under the West Bengal Estate Acquisition Act. Both according to the definition of intermediary provided in West Bengal Estate Acquisition Act, and also within the scope of Section 4.1, I must say 4.1, that except intermediary right or riot or under riot, after 1 year from the chapter 6 when come into operation, your lordship knows that those are the two classified of categories of tenants, that their rights will vest, and their estates will vest, and their rights in the lands will vest. This is the scope of the West Bengal Estates Acquisition Act. So, the definition and also Section 4 clearly prescribes that the only rights of intermediary or riots or under riots will vest under the West Bengal Estates Acquisition Act, not the rights of non-agricultural tenant. That was our first contention, because we say that Dakhalkar is a non-agricultural tenant, and it has been held by this Honorable Court as far back as in 70 CWA. And other judgments are there in 1967 Supreme Court, where it has been held that the rights of non-agricultural tenant doesn't vest under the state. So, the two things are there. We are non-agricultural tenant by virtue of recording as Dakhalkar. So, and the rights of non-agricultural tenant doesn't vest under the West Bengal Estates Acquisition Act. This is our first submission. Now, my lord, what the tribunal has held, he has interpreted Dakhalkar in its own way, without distinguishing 70 CWA, that Dakhalkar means simply possessor. That doesn't mean it's a non-agricultural. And then they have traveled to the Transfer of Property Act, etc., and even one provision of Bengal Tenancy Act. I will come to that. Judgment is a very tribunal judgment or order is a very long one. So I will come to your lordship very long. So, my lord, I am just formulating this point. First of all, my lord, the under West Bengal Estates Acquisition Act,
what about Section 3A?
3A will come after 1981.
Your source before.
Yes,
50.
Your source before. And we are even either the erstwhile intermediate, erstwhile the owner, or the subsequent purchaser. And 3A2 is very relevant. He will be a directly a riot with effect from the date of coming into operation of the West Bengal Land Reforms Amendment Act 1981. Right. That is there. So, our case is also that by virtue of 3A2, we became riot under the state in 82 with effect from 81. That is there. So, then, Miller, second aspect, Miller. So, Miller, this is the clear submission before your lordship, and before the tribunal, this was there. Secondly, Miller, extreme submission I am making.
What is extreme submission?
Extreme submission is this, Miller, even if they are intermediaries, these companies, still then this property 6.3 will not be applicable in view of the series of decisions of this Honorable Court.
Because industrial used for.
Yes, this court has consistently held that if the lands held by mere or factory owners is below the ceiling limits prescribed under the West Bengal Estates Acquisition Act, then those properties, in respect of those properties, 6.3 will not apply. Here, our dispute is with regard to 4.7 acres of land only. And out of that, some portion has been exchanged. So, we are concerned with 4.78 acres of land. So, in view of the series of decisions of this Honorable Court, in extreme cases, this property shall be allowed to be retained and 6.3 will not apply. But the government's approach all along in respect of this case, even your lordships will kindly read 4B2, that also refers to 6.3. So, they are to apply all the law. They have to, my lord, follow me upon, take me the position that we are guided by 6.3. If we are not guided by 6.3, 4B2 has no manner of application and other provisions have no manner of application. This is the second limit of submission. And if that is so, my lord, this order of conversion, which has been held to be without jurisdiction, that is also illegal because of this reason. That also the circular.
Section 60 of the Estate Acquisition.
Yes. No, I will come to this provision. Now, my lord, just for a moment, 2 or 3 documents I want to show your lordships. But kindly take for a moment for our supplementary affidavit. My lord, supplementary affidavit. Before going into the judgment, we will kindly take our supplementary affidavit, which you have filed. I will not. The tribunal has only 1 or 2 documents. The supplementary affidavit kindly come, page 12. So many mistakes have been done. I will point out to your losses. Now, Haridas Bandyopadhyay Dong,
Dakholkar.
yes, Ganges Valley Bone Mill Company, we have purchased the property either Ganges Valley Corporation or their successor. Dakholkar and others documents, almost all documents are Dakholkar except 2 or 3 cases. Except,
Yes, he's catching your back literally.
You wanted it pointed out that other than 4.7 acres, the company doesn't own any other.
Yes.
So, out of that, a very small portion is Lakhiraj, your lordships know, that is not, Lakhiraj is not the interest in the land. Lakhiraj is a rent-free land. Lakhiraj are the rent-free land, that is not the interest in the land. And some are recorded as Malik. This is this. Now, before the, again, now this is our.
Malik part?
Malik?
Malik part, what about that recording? What is your submission on that?
Malik part, unless I will come to that for the, unless it is recorded that they are intermediary or riot or under riot, their rights will not vest in this state.
So according to what is the connotation of Malik?
Malik, he is the owner.
It is owner.
Malik is the owner. Kindly visualize this. So far as the, I will come to the West Bengal estates acquisition. But before coming into that, kindly consider this situation. Original, the whoever now and prior to that, government is the paramount owner. Then after that, so many tenants or rights of the lands are intermediaries, tenure holders, the riots, under riots, everything, there. So, by Estates Acquisition Act, the rights of certain categories were sought to be vested. So, owner means he is a owner, but he is an owner under the paramount owner of the state. So, he is owner, so his right is not affected by the West Bengal Estates Acquisition Act. But that will be my submission. Now, secondly, kindly come to page 196, the affidavit in opposition of the government of West Bengal of the application, page 196 of the government, affidavit in opposition before the tribunal, where they have disclosed the revisional records of arrest.
196 of your writ petition?
Yes, of my writ petition. Kindly come to page 211. 1 or 2, I will say same thing.
211.
211. Affidavit in opposition starts there, but the arrest records of right there. Here, your lordships kindly see original owners' names are there. Here, also the Ganges Valley Limited, my name was recorded English 13/5/1962. Revenue reference. Dong, possibly vendor, something is, Mule Shalimar Industries Private Limited. Kindly mark this. But we say that this is wrong because Shalimar Industry was not the actual transferee. So this is required to be corrected. But that is not my actual purchaser was Shalimar Ware Industries. Whatever it may be, that is not so material here for the purpose of vesting. Now, kindly come to second column. Rights is most important. Atra Satyer Seni Bibhag Dakholkar. Then the next column is important. What we have also challenged to expunge this. Bhumi o Bhumi Bibhager such and such tariker a reference onusare Atra Satyer Sampatti Sampatti জমিদারি গ্রহণ আইনের 6th ধারামরে রক্ষিত. This we are objecting. How it can be?
That was your alternative argument.
Yes. No, not alternative. This is wrong. We want to expunge this from this records of right.
No, you made an extreme argument that.
No. Extreme second limb of submission, not my.
Even if this is not set aside, you are entitled to this.
Yes.
That is the last limb of your argument.
That's the last.
If everything else fails.
Yes. Even if it is not removed, still then they cannot, the property cannot vest in the state, and the conversion are required to be retained. So, Dakholkar, I do not want to trouble these same types of in the also.
So, inside the judgments, you said 2 line of judgments. One is that Dakholkar is entitled to retain the land. You mentioned 2 line of judgments.
Yes.
Show them. Cite those.
just now, or before going into the estates acquisition, very well, my lord. Your
No, no,
lordship.
whatever you like.
Yes, yes. Yes, 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 your lordship kind of
Sections during your arguments you have seen.
yes, yes, kind of 70 বাঁচটা দিয়ে দাও জজ দুটো জজ সাথে এই রে সর্বনাশ আই কান্ট সে পেজ দিয়ে তো জজ সাহেবকে দেখাও No, see the bunch that is the second judgment, that's page number টা বলে দিন page number
110.
yes
Surekha Datta.
yes mirror Osurekha Datta. Your lordships kindly come to para 15 and 16. Para 15 and 16 of the judgment. হ্যাঁ ওটা বলতো কি এটা 1966 online SCC online
Give a copy of the index page to Mr.
একটা কপি থাকলে দিয়ে দাও না আরে আমাকে যেটা দেবে বলেছিল সেটা দিয়ে দাও এর সমেত আমার কপিটা দিয়ে দাও give him my copy পুরোটাই দিয়ে আমাকে আমি কপি তো নিই নি
The Bera has it by heart, so
no, mirror this. If this helps, then mirror ultimately we are before your lordships to decide an issue. But this is no issue at all.
fair enough.
Not only your lordships has gone to come to para 15 and 16. Your lordships, lordships got
We are there, yes.
yes. Thus, the conclusion comes that the predecessor of Diptimoy let him the name now. Radharamon Pal took settlement of Dhopa Pukur with its Jolkor, Talkor, and all that is to say, with its land and water stands. Still remains the question, all question, what is the status of Radharamon or after him, the Diptimoy's father Rohini Kumar or after Diptimoy now? Upon a true answer to this question depends upon the face of this litigation depending before me. To begin with the records of right, Khotian number such and such, exhibit, etc., within the limits of Bardwan municipality in the name of Diptimoy intimate predecessors Rohini Kumar Pal, entering his status as a Dakholkar on the basis of Patta exhibit A in favor of Radharamon Pal. A Dakholkar is not and cannot be a riot. Plainly, he is a non-agricultural land. So was to start with Radharamon paying rent half an year to Lala Nirmal Kumar, etc. as Patta and the Kabuliyat of the 1901 exhibit A and to go to so. So Diptimoy father Rohini Kumar paying rent, the same rent to the foot of the same document to the superior interest of the landowner, the tenure holder, etc., etc. So, my lord, the point is the Dakholkar. I will, my lord, also argue before your lordships another point with reference to kindly mark that where it has been recorded as Dakholkar. Whether is a Dakholkar, the decision of this honorable court clearly shows not only that this decision has been followed in so many days in preemption cases, etc. So many cases, decision has been consistently followed. Dakholkar is a non-agricultural attempt. Now, this is the point. Now, Lord, so far as before going into the other judgments, now, Lord, your lordships kindly have a look to West Bengal Estates Acquisition. I have two documents I have shown. Lord, the LR records also say, your lordships kindly for a moment, because I will not trouble your lordship. Kindly come to, for a moment, come to LR records issued on, kindly come to page 161 of my petition. That was initially issued by the state. Therein, my lord, in 161 and onwards of the application, there is nothing recorded in remarks column. I say no 63 remarks. No, but I may say, my lord, the RS records of right there. It may be a mistaken one, I am not master saying, but this was issued. Then, my lord, kindly come to page, the last records of right, page 157. This is the on lastly issued 18th of March 2024. Here, everything has been recorded. Now, name is correctly recorded, Shalimar Wars Industry Limited, but in the remarks column, that পশ্চিমবঙ্গ জমিদারি অধিগ্রহণ আইন 1953 63 ধারা প্রযোজ্য। That was in consonance with the
Carry over from that previous.
yes, that was in consonance with the remarks made in the arrest records of right. Number one, we challenge this. This cannot be done because non-agriculture in respect of non-agricultural tenants, 63 West Bengal Estate Acquisition Act doesn't apply. For to speak of 63. If your lordships hold that they are non-agricultural tenant, not non-agricultural land, whether a riot or intermediary can hold non-agricultural land, no problem in it. Then he will come intermediary within the purview of Estate Acquisition Act. But non-agricultural tenancy that is governed by 1940 West Bengal Non-Agricultural Tenancy in 1949. That is completely a defined concept, and that has been clearly exempt from the purview of the West Bengal Estate Acquisition Act. Now, my lord, these are the three recordings. We have challenged this. Now, kindly come to West Bengal Estate Acquisition Act. আমার বইগুলো জজ সাহেবের কাছে আছে না, আমাকে দিয়ে দাও, অনেক বই আছে, আর দুটো বই আছে, দিয়ে দাও। বেয়ার অ্যাক্ট তো নেই, my lord. I lordship bear act or I can hand over.
We have bear.
West Bengal Estate Acquisition.
Acquisition.
আমার কাছে আছে বেয়ার অ্যাক্ট না হলে ঠিক আছে, জজ কাছে রয়েছে বলছি। তোমরা কাইন্ডলি কাবে হ্যাঁ হাজার লর্ডশিপ গট ইট একে হ্যান্ড Number kindly come to straight away the definition of intermediary. Mirror section 2.
Yes.
I.
Right.
Intermediary means a proprietor, tenure holder, under tenure holder, or any other intermediary above a riot or a non-agricultural tenant and includes a service tenure holder and relation to mines and minerals, include a lessee and a sublessee. So these are the non-agricultural is clearly excluded from the purview of the definition of intermediary. Above non-agricultural tenant, non-agricultural tenant. And subsequently, after chapter 6 came into operation, this intermediary will also include riots and under riots. After 1 year just. After 1 year just. Then we will kindly come to section 4 for a moment. For 1.
Yes.
The state government may from time to time by notification declare that with effect from the date mentioned in the notification, all estates and the rights of intermediary in such estate situated in any district or part of a district specified in the notification shall vest in the state free from all encumbrances. Then 2, the date mentioned in every such notification shall be the commencement of an agricultural year, and the notification shall be issued so as to ensure that the whole area to the extent vests in the state on or before 1st day of Boisak, that is 1362 BS. That is for the intermediary, that is equivalent to 15th of April 1955.
Only intermediary lands west.
Yes, and after 1 year, that is 1363
That
BS.
is not relevant here, not necessary.
That is not relevant. So mark this word, that rights of every intermediary.
Yes, obviously.
Obviously, because of this reign, now because of this region, then how government will ascertain?
We are first required to decide whether Dakholkar is intermediary or not. That is the crux of the matter. If that is decided in your favor,
yes,
the rest automatically follow.
Yes. Then another point.
Not follow.
Yes.
Not apply.
Another point I want to, because I want to emphasize on section 4. This intermediary, this is the word. Then who are intermediary and when? That is on 1st Boisak 1362 BS. So there must be some positive documents before the government to ascertain who were the intermediaries on the date of vesting, that is 1st Boisak 1362 BS. That's why, The West Bengal States Acquisition Act also provide that section 39 of the West Bengal States Acquisition Act clearly provides 39, will kindly have a come to section 39.
Yes.
The state government shall prepare the record for the purpose of carrying out the purpose of this act. This is most relevant. And if your lordships had the rules, Rule 25 and 26 provides what are to be recorded in the records of right. Rule 25 and 26 provides what are to be recorded in the records of right.
Don't have the rules in this.
Very well, we need not go into that. So,
Rule 25 and?
Rule 25 and 26. People, I can hand it over to you, but it is not much relevant. What are to be? So, primary concern of the government to apply the West Bengal States Acquisition Act to decide the rights of intermediaries or the vesting. Then, the records of right is to be prepared under the West Bengal States Acquisition, not under India, and therein everything should be recorded. Because then, your lordships kindly come to this your lordships know, this rights of intermediaries subject to right of retention under section 6. So, an intermediary, his rights will vest in this state. If he is not in a possession, and if he possesses through riot or under riot, then the question is different. But if he holds some land, and if some lands are in possession, he shall be allowed to retain those lands. And that is also, we will kindly come to section 6 for a moment, just one paragraph. Notwithstanding anything contained in section 4 and 5, an intermediary shall, except in cases mentioned in the proviso to subsection 2, but subject to other provision, that subsection be entitled to retain with effect from the date of vesting. Here also with effect from the date of vesting. So, date of vesting is the crucial. Then your lordships kindly come to section 6.3. What is the dispute here? In case of land comprised in tea garden, mill, factory, or workshop intermediary, or where the land is held under a lease, the lessee shall be entitled to retain only so much of such land as in the opinion of the state government is required for the tea garden, mill, factory, workshop, as the case may be, and the person holding under a lease shall, for the purpose of assessment compensation, be deemed to be an intermediary. So, government want to take advantage of this, that we are as if we are intermediary, so they can decide that what quantum of land we shall be allowed to retain. But this is under the second limb of submission. This court has held where the land is within the ceiling limit, you cannot apply 60.
The question of retention does not come.
It doesn't come.
Ceiling is relevant for that.
Then, in that context, but I want more submission. Your lordships has seen the records of right. Finally, published records, revisional records of right, which are produced before the tribunal. Now to some extent, I am making negative submission. In the records of right, it must be recorded that this person is an intermediary of the land or he is a riot or under riot. Only if these two criteria satisfied, then only West Bengal States Acquisition Act apply. Yes. In the records of right, both in the, not CS doesn't come, in the RS records of right, only status is the Dakhalkar. So if we approach it from a negative side also, so you cannot apply because we are not intermediaries or we are not riots or under riots. Now, my lord, so, my lord, this primary finding of the tribunal that we are riot or under riot or intermediary 6.3 applies, that is absolutely wrong. Absolutely wrong. Now, your lordship, then your lordship kindly come to the decision portion. I have less people, your lordship. সেটা তো ওদের ওখানে যায়নি, ট্রাইব্যুনালের অর্ডারেই পেয়ে যাবো। ট্রাইব্যুনালের অর্ডারে কি করেছে সেটাও জড়িয়ে দিয়েছে। মানে না your lordships kindly come দেখি আমাকে জাজমেন্টটা আমার আলাদা পোর্শনে আছে। Your lordships kindly come to judgment portion, my lord. page 78. Something has been everything.
Refer to the internal pages, Mr. Bera. We are following from the
Internal
copy.
pages
At the top.
at the top. My so far as my copy is concerned, all are yes. Internal page is there. But I will come to your lordships. Where facts have been stated, and your lordships decision on earlier occasion that has been quoted in its entirety. Thereafter, your lordships come to internal page, where the actual finding starts. Mirror page 21 of the event. Page 21. Mirror, I am not troubling your lordship with these long decisions where it has been repeated. I am learned advocate appearing for the applicant company has submitted this. It is crystal clear from CS records of right that the precision interest of the applicant was recorded as a dakhalkar, which means
The CS also you were Dakhalkar?
yes, I have produced.
All of it. CSRS.
I have submitted a supplementary affidavit that was filed. Supplement that was filed. Unfortunately, missed it to include in our petition. That's why we have filed a supplementary. It was before the tribunal.
Yes.
Supplementary affidavit that was before the tribunal. Which means an organizational tenant under the Toji holder, and there is no provision in the applicable estate acquisition for vesting of interest of the non-aggregator. In the absence of such provision, it must be said that the interest of the non-aggregator does not vest. Mirror, I will not trouble your lordship with so much things. Mirror, next contention forwarded by mirror your lordship. Kindly skip it over. The government is presently. Mirror. Now, my kindly come to 28. Before that, issues have been framed. So, we are primary contention, we are non-agricultural tenant. So, this property doesn't fit. The applicant submitted a supplementary CS records of right. Needless to mention that the CS records of right were prepared as per provisions of Bengal Tenancy Act 1885 and enacting the law related to land on tenant. Then we are one Khotian and plot your lordships kindly see that page 29. Other same everything has been repeated. I do not want to say. Then kindly come to page 30.
Yes.
Only description in the records of right has been narrated by the tribunal. Middle paragraph. The term dakhalkar signifies a possessor or a person having possession, but technically the Bengal Tenancy Act 1885 does not explicitly define this term, often distinguishing them from the recognized agricultural tenants. If a dakhalkar is already a riot holding homestead land in the same village, 182 of the Bengal Tenancy Act may apply, allowing them a status of riot for that homestead. But your lordships kindly come for a moment. Will have your
BT Act আছে
BT Act বইটা দাও আমার বই বড় বড় বইটা যেটা ল্যান্ড ওটা না ওই বড় বইটা নীলটা
Bengal Tenancy
182 meters completely misconstrued. If your lordship has got it, or I am telling you. I need not read it. This is your lordships kindly take the part.
Homesteads. One is sufficient.
When a riot or an under riot holds his homestead otherwise than as a part of his holding within the same village or any village contiguous to that village, his status in respect of homestead shall be that of a riot or under riot according to the status of the landlord of the homestead and incident of his tenancy, and such homestead shall be governed by the provisions of this act applicable to riots or under riots, and as the case may be. So it starts with the word. He must be riot or under riot. And the position, the section speaks that if riot under riot holding some land, in the same village he holds homestead, or in a contiguous mouja he holds homestead. So he shall be deemed to be a riot. So this has no application here. Then mirror, kindly come to the decision of the tribunal. Page 30. A dakhalkar was recorded in such Khotian records of right frequently indicating possessory right rather than possessory right of an occupancy right. No such case has been made out by the applicant company that tenancy was created under the Bengal Tenancy, under the Transfer of Property Act, not under the Bengal Tenancy Act. In fact, in the instant case, no question raised whether the tenancy was governed by Bengal Tenancy Act or by the Transfer of Property Act. In the present case, there is no doubt that the predecessor interest of the applicant company was a riot holding homestead otherwise than part of his holding. And that being so, with regard to the homestead, the tenants become a riot under the Bengal Tenancy Act. So recording of the term Dakhalkar in the CS records of right does not ipso facto leads to an inference that the predecessor and interest of the applicant company was a non-agricultural tenant, particularly when no case has been made out by the original tenancy was covered under the Transfer of Property Act, not under the Bengal Tenancy Act. But this is absolutely misconceived. Because of this reason. Our rights are recorded in the CS records of right under the Bengal Tenancy Act. We are the Dakhalkar. This is mirror. Then mirror, this is one part, this is absolutely wrong. Then mirror, some with regard to observation. No, mirror, kindly come to, starts with last para. Authenticated, last but one para, authenticated copy of RS records of right in respect of subject plots have been annexed with the evidence in opposition, examine the RS records of right and etc. Then mirror, RS Khotian number 322, Mauja Uttarpara such and such reveals initially plot number such and such classified as Bastu was recorded in the name of Ganges Valley Corporation Limited as Dakhalkar. Then RS Khotian number further reveals that it was a finally published records of right emerges that the RS Khotian number 322 on such and such that name of Salimas Industries Private Limited was incorporated. This is kindly mark this. How this court has proceeded. It emerges from the RS records of right Khotian number such and such on 21st of June 1967. Name of Salimar Industries Private Limited was incorporated in a proceeding under section 44(2) of the West Bengal Estates Acquisition Act on the basis of registered indenture dated 31st of May 1962. It comes out that the RS Khotian, noting that the retention by such and such was issued to the state of West Bengal in favor of Salimas Industry Limited under section 6(3) of the West Bengal WE Act 1953 was also incorporated in the Khotian on the same date and in the same proceeding under 44(3) of the West Bengal Association. But this is absolutely misconceived. What is to be considered? The intermediary or riot on the date of vesting what he was holding. Not I, the subsequent transfer. I admit that I am a post-vesting purchaser. There is no doubt about it. I have purchased in 1962. What is to do with my recording?
Character does not change.
Character does not change.
It was there on that record. Obviously.
So this 60 and again, against me.
My dear Mr.
Against
Vera.
me.
Yes.
Here you
consider elementary, my dear Mr. Vera.
Well, he is to record on the date of vesting.
That is bone mill status.
Bone mills. That is to be considered. So this is absolutely misconceived. So entire observation with regard to Dakhalkar is a misconceived one. Then on the basis of this I will not trouble your lordship. Now kindly come to same thing has been 44 times without number. Again your lordship knows this is also purely violation of principle of natural justice. The court must ought to have seen what was order was passed in 44 proceeding. That was not produced by the government. Without looking into that order, he is on
Was there any order at all?
I do not know.
On record, anybody produced?
No.
Not there.
Not such produced.
Wondering about that also when we saw this.
Yes. No such order was produced. Only on the basis of recording your losses, I shown to the RS records of right. After the status of tenancy, something was recorded. 6(3) ধারা মতে রাখিত পশ্চিমবঙ্গ জমিদারি উচ্ছেদ আইনের 6(3) ধারা মতে রক্ষিত. That was the observation only, and that has been recorded in the name that 6(3). Then I am skipping it over. Then on the basis of the your lordships kindly come.
Mr. Bera will come back and continue this.
Yes, yes.
Come back.
Right. Sorry.
No, no, Vice. Yes.
Nevertheless, I am placing I place the judgment, where your lordships of the judgment kindly for a moment come to page 23 of the judgment, for a moment. It is not that we have not pointed out. Page 23, middle two paragraphs.
23.
23. Relying upon the judgment of the Honorable Division Bench of High Court in Calcutta, WP LRT such and such, OBG tie-up Private Limited versus State of West Bengal, again pointed out that the non-agriculture was kept outside the purview of 1953 Act, did not affect or extinguish its operation. Then, inviting attention of the bench to the judgment of the Honorable High Court at Calcutta passed in Surekha Datta versus Divitumapal 70 CW, and the advocate's applicant has contended that the Holkar is not and cannot be riot, and plainly he is a non-agriculture. These points were not discussed. Then, your last portion of the judgment, your lordships kindly come to page 37. How here the tribunal has approached all negative. Page 37. Had the applicant company been a non-agricultural, and what prevented it from recording the subject land in the records of right under section 28 of the West Bengal Land Agriculture 1914? How this approach, if the government did not find out intermediary, did not prepare any revisional records of right in respect of any jamindar or intermediary, then can the jamindar be infected with the saying that what prevented him from preparing the arrest records of right? The applicant company has not filed any counterpart of the receipt showing payment of rent as per provisions of 46 of the West Bengal non-agricultural, read with Rule 16 of the West Bengal non-agricultural tenancy rule, issued either in favor of its predecessor in entire exemption. On the other hand, the recitals of the registered indentity dated such and such indicates clearly the predecessor in interest of the applicant company was the guide. I do not know where does he found, in which page, by provisions of WBA Act, not by the West Bengal Tenancy Act. In fact, in course of hearing, while the attempt has been made to substantiate the claim to the effect that the applicant company was
Mr. Chaudhary was responsible for this. He appeared and with his westernized accent and all, he overawed the tribunal, and we understand what happened there. We understand exactly what happened.
So this is that part, not agriculture. And now my next point, as to whether I will not take much of it. Next point, as to whether the order of conversion dated has already reached finality. Now we consistently said that it's reached finality, it cannot be touched, but that can't be the provisions of position of law. But if it is without jurisdiction, it shall be without jurisdiction. But the finding is this: records of right, your etc. room now kindly come to that. Your lordships has read this. I do not want to mass your lordships kindly.
On conversion, you don't have a direct submission.
No.
Regarding
Yes.
the adjudication
It has been set aside.
What?
It has been quashed. And he has again, I am not reading the entire judgment. I don't want to travel to your lordship. He has the tribunal has relied upon one circular. That their circulars and only one paragraph. That is at page 160.
You have a copy of the circular?
It has been quoted here.
This will be relevant only. This
will be relevant.
All right.
Because
the
the
entire
entire copy of the entire copy I
yes,
could not
yes.
collect.
No, the entire copy has been quoted here. Almost all.
Most of the part has been
Most of the
quoted
part.
from 11 and onwards.
Right.
Kindly come to page 116B. That the order directing change, conversion, or alteration is without prejudice to the provisions of subsection 3 of section 3(6) of the West Bengal. Same 3. If section 6(3) doesn't apply, then order of conversion is good. And doesn't mean then this on this ground the honor of conversion has been set aside. Being without jurisdiction. 6(3) apply. And so all 6(3). 4B2 Land Reforms Act, 6(3). So you don't have to take away my land. The government wanted to apply 6(3) of the West Bengal Estate Acquisition Act. So, the judgment is entirely in wrong. Then your lordships kindly come to only. I will not take much your lordships' time. The first judgment, Shiv Shankar Nandi, that is first judgment, Pravartak Sangho, para 9. Council, however, contended that the first respondent having merely the right to receive rent, it was an intermediary within the meaning of Act 1 of 1954, that under the Act, the interest of such intermediary vested in the state on the extension of that Act to the Chandannagar, and mirror therefore association had no locus standi to apply for transfer. The contention also cannot be accepted for an intermediary as defined in section 2(1)(I) of that act means a proprietor, tenure holder, under tenure holder, or any other intermediary above a riot or a non-agricultural tenant, and in relation to mines and minerals, a lessee or sublessee. It is thus obvious that the first respondent, being a non-agricultural tenant in respect of the entire land, including the land in dispute, it does not fall within this definition. Not being thus an intermediary, it is impossible to say that the interest in the land in dispute vested to in the state, or therefore it was not entitled to apply under section 24. So this is also both ways. Like Surekha Datta also, on non-agricultural tenancy doesn't vest at the state. Then mirror next judgment, your lordship kindly come to mirror the BRC construction. Third judgment, page 15. It starts from page 15. Kindly come to page para 38 and onwards. 38, I will not, everything has been discussed.
Come to para 61 directly.
There are 61. Very well. These judgments on paragraph 35, those judgments have been quoted very well, Mirror. 60. Yes. No, your lordships will kindly just one paragraph above, because I will rely upon that.
Sure.
We are informed that the decisions of this court on similar lines, para 60. We are informed that the decisions of this court on similar lines in Saregama India Limited, State of West Bengal, reported in 2014 to Calcutta Law Times, such and such. The State of West Bengal Star Iron Works, that I will rely upon, 2012 to such and such was challenged before the Supreme Court in India, and the challenge proved to be futile. That is important. Then mirror this 60. Our conclusion therefore is that the state cannot resume any land which is within the ceiling limit according to section 6(3) of the Estates Acquisition Act. So, if it is within the ceiling limit prescribed under section 6(1), you cannot resume any land. It must be in excess of ceiling limit.
Obviously. Yes.
Obviously. Then mirror this.
It's a question of retaining something which you don't lose in the first place.
Yes. Then as the land of the petitioner is well within the ceiling limit which exists structure, even assuming that the section 6(3) applies to the land, still the state cannot resume the land. That's my second limb of submission. I submitted with your lordship. Even if it is interim, you cannot touch my land.
State cannot do with structure.
Oh, the state cannot resume or any land with structure under section 6(3) of the State Acquisition, as it does not contain any provision for vesting of the state. Our land is there, structures are there, factory is there. Then mirror next judgment is এটা হচ্ছে কত mirror অভিজিৎ tie up
Running page 20.
Same কোন প্যারাগ্রাফ বলবো?
Running page 23, paragraph 1. অনেকটাই paragraph 9.
Paragraph 9. আমার কাছে তাই লেখা আছে। The same principle has been
9, 10. 9, 10 or 18.
18. The same paragraph in paragraph kindly marked in 9, 10, 13, and 14, 15, and ultimately 18. It has been quoted, various paragraphs of the other judgments have been quoted.
9 টা দেখে দেন clearly.
The past para 9, just a minute, mirror, for a moment, my junior is saying.
Page 28 of your compilation, running page.
Yes, running page 28. 28. The composite reading of the aforesaid provisions leaves no ambiguity that the non-agricultural tenant is stated to have held the tenancy under intermediary, and such tenancy has been kept outside the purview of the Act of 1953. The said non-agricultural tenant shall continue to hold the land directly under the state as the right of the intermediary vested with the state, and the state is regarded as the intermediary for the purpose of collection of rent and the other obligation attached to such non-agricultural tenancy, and shall continue to hold the said land on the same terms and conditions as was he before the date of vesting. Then mirror section 6 have been coded. I am not placing that. Mirror then kindly mirror the section 3A has been interpreted. Then we will kindly come to para 10. Upon incorporation, that your lordship was speaking, para 10 at page 30.
The cumulative effect.
Yes. Para 10. Upon incorporation of section 3A of the Act of 1955 for the first time, the rights and interests of the non-agricultural tenants stood vested in the state, free from all encumbrances, as those non-agricultural tenants were the intermediaries in the land held by them under estates, and the person holding the non-agricultural land were a riot. By virtue of the aforesaid section, the provisions contained in section 5 and 5A of the Act 1953 was extended to those non-agricultural tenants, meaning thereby that they would be regarded as tenant directly under the state and shall pay rent direct to the state. The subsection 2 of section 3 of the Act has overriding effect of subsection 1 of section 3A, which is primarily related to the vesting of non-agricultural tenancy into the state, be entitled to retain as a riot the said land, but subject to the ceiling limit of section 14 of the Act. The cumulative effect of the aforesaid provision leaves no ambiguity that the non-agricultural tenancy was kept outside the purview of 1953 Act and later on included in 1955 Act of 1955, and upon introduction of section 3 of the Act 1955 stood vested with the state, and their status was considered as a riot holding the land directly under the state on the same terms and conditions as it was before the date of vesting, however subject to the ceiling limit under the 14th. 4 acres of land, everything is in ceiling. Then we will kindly come to, I am stripping over other, we will kindly come to para. Other judgments have been
18 চলে যান 18 টা দেখেন
যেটা দেখাচ্ছি এখানে সব পুরো জাজমেন্ট কোট করা আছে না পেজ কত
পেজ 40 তে রানিং পেজ 40 তে প্যারাগ্রাফ 18
yes running page 40 paragraph 18 again same thing reiterate. Then mirror next judgment is which has been upheld by Supreme Court, mirror that is the report টা কি আছে আমাদের state versus Star Irons Company. Your lordship state will come to para 32 or one paragraph.
Yes.
Having regard to the scheme of the said Act, West Bengal Estates Acquisition Act, and the language of subsection 3, including the proviso thereto, there can be no doubt that section 6.3 applies only to mill and factory which were in operation or was functioning on the date of vesting. In respect of the mill which was closed long before the date of vesting, there could not be any question of assessing requirement of factory. Section 6.3 does not directly deal with the right of retention. It really deals with the extent of retention, and such extent is required to be determined having required to the requirement of the mill or factory.
This is actually on a different point somewhat.
Somewhat, but
it had to be
again,
at that point of time.
Again, with the last judgment was the same principle of this honorable court, para 14, that is mirrored the Nikhil Chandra Sannal, same principle. Nikhil Chandra Sannal, para 14, last judgment. Same principle. Principle laid down in this decision is that only intermediary vest, para 14. Same principle. Judgment of this honorable court, division bench judgment of this honorable, long back, 1792. The old judgment sometimes we rely.
Absolutely.
Sometimes.
Mostly they are right. Yes.
Yeah.
No, this is actually on the proposition you are submitting.
Yes.
The previous judgment was somewhat different point when it will come under 6.3 and all.
Repetition.
This is squarely, yes.
Yes. So, the most respectful submission is this. So, first of all, because of recording the whole car,
yes,
we are not non-agricultural tenant. Non-agricultural tenancy doesn't vest under the West Bengal Estates Acquisition Act. But to speak of section 6.3, so that I will apply. So, mirror the observation made in the RS records of right and also in the LR records of right subject to sections 3 is erroneous and that is liable to be quashed or set aside. That we have approached before the tribunal. That was not done. And secondly, in our application, we have said ultimately, initially our name was recorded, ultimately, finally, which was issued to us, our name was properly recorded. But in our application, the categories of land after the conversion, after that, the order of conversion was rightly passed because 6.3 has no manner of application here. If the order of conversion is rightly passed, then or correction of records of right in respect of LR records of right in respect of the categories of land which was allowed by order of conversion, that must be recorded in the LR records of right. That was our submission, both in our application for correction of records of right, where it was said your name has been corrected, but the categories of land which are allowed by conversion, that was not allowed. And now, my lord, everything has been set aside by the tribunal according to my respectful submission, which is absolutely illegal. So, my lord, this should be done. Our entire prayer should be allowed by this. That is that's my respectful submission.
Yes.
না আমি বুঝিনি একটা আমার মতো করে কাগজ বুঝিনি আমার একটা ছোট বই ছিল কোথায় গেল পুরোনো বই
As I understand from the submission of my learned senior as well as from the records, the more question for determination is the threefold. Number one, whether the petitioner is a non-agricultural tenant or not. This is, I think, this is the crux of the matter, that if he is a non-agricultural tenant, then he can get the benefit, benefit that he will not be, this property will not be vested. Number two, whether the Dakholkar comes within the definition of non-agricultural tenant or not. And number three, whether the petitioner is barred by the principle of estoppel, as he has not challenged the order of 6.3.
Was there any order? We don't find
there is a reference of the order,
I can see the order.
Exactly.
You refer to the last 14 years, the last your predecessor referred to the last previous 34 years, and you don't produce the records.
What I find, that there is a date and proceeding number is there in the record of right. And we'll consider. Lastly, that whether the order of conversion passed.
We said, if the state can't produce that order, what will they challenge? It was your recording. State recorded. If the order is not found, even if the state can't produce before this court, despite our asking, how are they supposed to challenge? What are they supposed to challenge? In thin air, a recording is to be challenged. They have challenged that.
But I think when the order was passed, they were not there because they had purchased the property in the year of 1962.
So therefore, their predecessor did not challenge.
Yes. Now, kindly first,
yes.
First, kindly consider that there are three classification of recording. One is Dakholkar, another is Malik, and thirdly is Lakhiraj. As well pointed out by learned senior. So far as Lakhiraj and Malik is concerned, those are intermediary, as I find from the guide and glossary of the survey and settlement records in Bengal of 1917.
Is it a binding document?
This is a document which is followed.
We got 3 copies at least, for both of us. 3 copies.
I will hand
them also.
I will hand over.
But this is a document which is not usually found.
I will.
You're a senior standing counsel, you have it.
I can bring it.
Anyway, what is your argument on this?
Here, I will hand over just after getting Xerox. Here, what I find that the Malik.
Just refer to the what
page number. First,
what is that?
The Government of West Bengal Guide and Glossary to Survey and Settlement Records in Bengal.
We don't know shorthand.
I'm sorry.
Guide and Glossary
to Survey and Settlement Records.
Yes.
in Bengal, 1917. Though matlab, I have this book matlab, at least 10 years ago, matlab, not holding this matlab, post. Now, matlab,
1972.
1917.
17.
17. This is matlab, basically after the Bengal Tenancy Act, while matlab, the authority recorded, matlab, prepared the CS record of right, they followed this glossary and matlab, all the matlab, the classification that like Malik, Rayat, Lakheraj, everything matlab, you will find from this glossary.
First of all, Mr. Bhattacharya, can that override judgments of court?
Matlab,
Secondly, the
I'm coming,
statute.
matlab, all the judgment as by cited by my learned senior, those are matlab, on the matlab, a clear point that non-agricultural tenant is not covered under.
No, one or two of them refer to Dakholkar.
Matlab, I'm coming, matlab, I'm Dakholkar, matlab. I'm that is the reason matlab, I'm requesting Lordship to frame 4 questions.
One is non-agricultural tenancy, whether.
First, whether.
Second is.
Dakholkar come within the definition of non-agricultural tenancy.
Yes.
So, matlab, kindly take these 2 points together.
Very well.
Now, matlab, what.
Third point was estoppel, 6-3.
6-3.
What is the fourth point?
Fourth point is whether the order passed by the authority in the conversion order, that is a nullity or not. Because if the authority don't have the jurisdiction, then matlab, he cannot pass the order on this court. So, matlab,
which authority passed that order?
Matlab, SDL or I'm just showing.
Ask your engineer to check up.
Yes, matlab, this authority, District Land and Land Reforms Officer, 4C authority, matlab, at page 144.
The collector and the 4C.
4C. Matlab, I'm just handing over matlab, this glossary.
Yes, yes.
Ready to Xerox.
No difficulty.
So, matlab, this matlab, whether matlab, a person is a non-agricultural tenant or whether a property guided under the Non-Agricultural Tenancy Act or not, that is matlab, considered in matlab, the act itself. A Dakholkar, it may be matlab, an illustrative but not an exclusive definition, because there are some criteria to be a non-agricultural tenant which is specified in the act itself. Matlab, kindly consider the Non-Agricultural Tenancy Act once.
Then non-agriculture tenancy আগে ছিল বলে দেখি ওটা আছে দিন 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 এটা থাকা উচিত এটা থাকবে না শুধু হচ্ছে পি থেকে শুরু হচ্ছে MNOP এটার আগের ভলিউম 17-16টা লাগে MNOP
কবে বার করে একটা আমি একটা বলছি দুই তিনটা করছে
Yes, which provision?
Matlab, kindly consider section 2(4) first. Non-agricultural tenancy, West Bengal non-agricultural tenancy of 1949.
Yes.
Non-agricultural land means a land which is used for the purpose not connected with agriculture or horticulture and include any land which is held on lease for the purpose not connected with agriculture or horticulture, irrespective of whether it is used for any such purpose or not, but does not include a homestead to which the provisions of West Bengal Land Reforms Act apply. The land which was originally leased for agriculture and horticulture purposes, but is being used for the purpose not connected with
Which are
agriculture.
we relying on? D.
B.
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 Land.
24B.
Why this was land originally leased for agricultural or horticultural purposes?
No, my lord.
Then
I'm just referring, my lord, the definition of the non-agricultural
yes,
land.
but how
and
is this
tenant.
relevant here?
Relevant is, my lord, if you consider, my lord, the tenant's definition of tenancy, my lord,
Yes.
then, my lord, non-agricultural tenant means a person who holds non-agricultural land. So,
yes.
So, if a land which is not used for agriculture and horticulture, and if a person holds that land, he is only, my lord, entitled as a non-agricultural tenant under another person. My lord. This is very important. So, I have to hold a land under a lease.
No, not have to, and includes any land which is held on lease for purpose not connected.
But for a special contract. My lord, I'm referring to 5.
Oh, achha, achha. Achha, very good.
May I give you another copy? 2.5. Non-agricultural tenant means a person who holds non-agricultural land. In this particular case, even if we presume that he is a non-agricultural tenant, so far as the nature of the land is concerned, there is no quarrel. He is holding a land which is recorded as mill. But kindly consider the second part. Under another person and is, but for a special contract would be liable to pay rent to such person for that land, but does not include a person who holds any premises or part of any premises situated on non-agricultural land and erected or owned by another person, or who is, but for a special contract, would be liable to pay rent for such premises or such part of the premises to such persons. So, my lord, here to be a non-agricultural tenant, I have to hold the land under another person and I have to pay the rent. Now, my lord, kindly consider section 3, the classes of non-agricultural tenant. There shall be, for the purpose of this act, the following classes of non-agricultural tenant, namely tenant or under tenant. Now, who is tenant? Tenant means a person who has acquired a right to hold non-agricultural and directly under the state for any of the purpose provided in this act, and includes also the successors in interest of persons who have acquired such right. Under tenant means a person who has acquired the right to hold non-agricultural land for any of the purpose provided in this act, either immediately or mediately under a tenant, and includes also the successor in interest of the person who have acquired such right. So, if we may not consider section 3, there are 2 parts, whether I may be a tenant or I may be an under tenant. But I have to hold the land under some superior landlord by way of lease or under the lessee of a state. Then, my lord, section 5. I think, my lord, it helped, my lord, my learned friend's case, because this includes the manufacturing unit. Section 5B, for manufacturing or business purpose. If such tenant is entitled under the terms of any agreement between himself and the landlord to use or is actually using such land for carrying on therein any commercial or industrial enterprise or any trade or business. And so, being a tenant, I can use the land for industrial purpose, for business purpose, But the one of the paramount consideration is I have a superior landlord. Now, my lord, this is another very interesting part, which is section 7 of the Act. It is not a my lord, merely I can hold a tenancy under 1 or 2 years and claiming myself as a non-agricultural tenant. There is a time bound, which is minimum 12 years. My lord, notwithstanding anything contained in any other law for the time being in force or in any contract, if any non-agricultural land has been held with or without any lease having been entered into by the landlord and tenant from before commencement of the Transfer of Property Act, or if the origin of any tenancy is unknown, or if the non-agricultural land comprised in any tenancy which has been or is created after the commencement of the Transfer of Property Act 1882 has been held for a term of not less than 12 years without any lease in writing. If any non-agricultural land has been held for a term of not less than 12 years under a lease in writing, but no term is specified in such lease. If any non-agricultural land held under a lease in writing for a period specified therein continues to be held with the express and implied consent of the landlord after expiration of the time limited by such lease, and the total period for which such lease is so held is less than 12 years, or if the landlord has allowed pakka structure to be erected on any non-agricultural land held under a lease in writing for a period specified therein, whether such structure have been
This
erected.
only provides a provision where he can be ejected or not.
Yes, but my lord, one of the
Does not
conditions
necessarily
is
have to come within this.
yes,
And here also origin is unknown is also covered.
but my lord,
This says in these cases
if
landlord
the
cannot
number
reject
one-
without this.
if I am unable to fulfill number 1, that is my lord 7(1),
If you don't fulfill any of this, still you can be a non-agricultural tenant.
I have to fulfill the condition of section 4.
Yes,
and 4.
the others will remain.
Now, my lord,
3 and 4 comes in.
yes,
But you need not be a non-agricultural tenant for more than 12 years. We don't accept that.
then my lord,
Or if you are, then you are protected from eviction in certain cases.
yes,
This is not a qualification or an essential criterion for becoming a non-agricultural. This is an additional cloak of protection given to more than 12
as I understand, my lord, this non-agricultural tenancy act has a root with the Transfer of Property Act. The basic root of non-agricultural tenancy act comes, my lord, from the Transfer of Property Act, as I understand, my lord, because in Transfer of Property Act also, my lord, there is a provision of lease, and this non-agricultural tenancy act, which is also dealt with the tenant under tenant of a my lord, as a lessee, my lord, in respect of non-agricultural land. Now, my lord, if I am a lessee, then my lord, I have to pay the rent. That is covered under section 46 and 47 of this Non-Agricultural Tenancy Act. Every non-agricultural tenant who makes a payment on account of rent to his landlord shall be entitled to obtain forthwith a written receipt for such payment, either from such landlord or where the
That's why the expression tenant, non-agriculture, not occupant.
Occupant, or where the agent of such landlord has been authorized in writing to such landlord to issue and sign such receipt on behalf of such landlord from such tenant. Well, then the other, the counterfoil, those are there. Now at 47, non-agricultural tenant entitled full discharge or statement of account at the close of year. So first rent receipt.
So you have to be a tenant in the first place to become a non-agriculture.
Non-agricultural
tenant and land not used for agriculture.
Now,
Or agricultural
I put a question to myself: how can I prove that I am a non-agricultural tenant? The only, as bare reading of this act,
tenancy.
what I understand, my lord, the only thing is 46 and 47. And my lord, the rules, this my lord, 46 and 47, this is my lord, what I am trying to refer from this act. Now, my lord, if your lordship kindly consider the rules. My lord, rule 16. My lord, may I hand over, my lord?
Yes, hand
Only 2 lines is there, my lord.
2 lines, then hand over.
That is, my lord, the receipt. Rule 16. I'm sorry, my lord, it's marked.
Yes. Yes.
So, my first limb of submission that whether I'm a non-agricultural tenant or not, to prove that or to substantiate my claim, either I have to produce a rent receipt or the statement of account which was given by the landlord to the tenant. This is, my lord, one of the primary condition of to prove as a non-agricultural tenant. Mere recording as a dakholkar, it cannot be an exclusive term to define that all the dakholkars are non-agricultural tenant.
So not only non-agricultural, but tenant. Tenant aspect has to also be looked at.
Absolutely, my lord. Now, my lord, the second part is the application of 6.3. My lord, kindly consider the provisions of the Estate Acquisition Act. And my lord, in this case, there is, I will show, my lord, that their deed of purchase of 1962. My lord, 7 except the recording of dakholkar, there is no iota of document to show that they are paying rent or their predecessor in vendor is paying rent, or even from the deed itself, it can show that the predecessor or vendor paying rent either to the state or any superior landlord. Their deed also remains silent on this scope. Now, my lord, before, my lord, going to the definition of the intermediary, I'm just requesting your lordship to consider section 4 and 5 of the Bengal Tenancy Act.
Yes.
There shall be, for the purpose of this act, the following classes of tenant: tenure holder, including under tenure holder, rayat, under rayat, that is to say, tenant holding whether immediately or mediately under rayat, and following classes of rayat, namely rayat holding at fixed rate with expression such and such, occupancy rayat and non-occupancy rayat. I'm not required to read, my lord. And my lord, the meaning of tenure holder and rayat. Section 5. The tenure holder means primarily a person who has acquired from a proprietor or from another tenure holder a right to hold land for the purpose of collecting rents or bringing it under cultivation by establishing tenants on it, and includes also succession in interest of the person who have acquired such right. Rayat means primarily a person who has acquired a right to hold land for the purpose of cultivating it by himself or by members of his family or by servants or laborers or with the aid of the partners, and include also the successor in interest of person who have acquired such right. Now, Malat, kindly come to the definition of intermediary, because the term used in the intermediary, those are defined in the BT Act. Intermediary means a proprietor, tenure holder, under tenure holder, or
This is
intermediate.
section
Section 2I. Above a riot
of the,
of the Estate Acquisition Act.
you said Bengal Tenancy.
No, I'm just saying Bengal Tenancy Act. These two sections I have referred. Before stating the definition of
Intermediate definition is there in the, it was placed by Mr. Beros.
because the term used in the definition of intermediary, those are defined in the BT Act.
So why did you rely on 4 and 5? You don't understand.
Pardon, my lord, this
Why do you rely on 4 and 5 of BT Act?
because my lord, this term of tenure holder, under tenure holder, those are defined in the BT Act.
But suppose riot is defined also cultivating,
Yes.
which is quite contrary to non-agricultural tenancy.
My lord,
And why are you, why, how is this German?
my lord, only to my lord, the
Tenure holder is a different concept, maybe a different concept from a tenant.
yes. Now, my lord, I'm referring my lord, section 4 and 5 only because the word intermediary as defined in the Estate Acquisition Act, this my lord, proprietor, tenure holder, under tenure holder.
So you draw commonality as regards tenure holder.
Yes, my lord, from my lord, the BT Act. Because my lord, in the Estate Acquisition Act, nowhere it is defined the definition of tenure holder or under tenure holder. That is, my lord, to bring the chronology, my lord, that is the reason, my lord, I am referring this.
Good.
Now, my lord, kindly consider the non-agricultural tenant that has also been defined in the Estate Acquisition Act. 2K. Non-agricultural tenant means a tenant of non-agricultural land who holds under a proprietor, a tenure holder, a service tenure holder, or an under tenure holder. So, if I want to claim myself as a non-agricultural tenant, I have to establish first that I am holding the land under, my lord, this 4 category of person. Either of these 4 categories of person.
Your tenure holder gets vested,
yes,
as an intermediary, but you you are
I
under
am
under
holding.
him, yes.
I am holding the land under a, my lord, in a common terms, I am holding a land under the intermediary. But merely a
lowest in the rung.
Yeah,
but
absolutely.
there has to be someone in the middle also.
Absolutely, my lord.
And suppose a trespasser or a licensee.
My lord, trespasser, my lord, more precisely, my
question of rent.
my lord, I tell you, lordship, my lord.
Licensee also.
Yes.
Because rent does not cover a license, strictly speaking.
Absolutely, my lord. And my lord, that 2-3 matters after, my lord. A matter is there in the your lordship list. That is, my lord, relating to the same issue. Now, my lord, so far as, my lord, the non-agriculture to establish myself, what I'm trying to, my lord, harp upon, that there should be a person immediately before me. Now, my lord, kindly come. Section 5 of the Act.
Not only a person above you, you have to pay rent to that person.
Yes, my lord. First, I have to hold a land, my lord, under a person, under a tenure
First
holder.
is it has to be non-agricultural.
Non-agricultural.
Second
land.
is you have to hold under a person above.
And then, my lord, I have to pay the rent.
Because rent specific provisions are there.
46 and 47.
Right.
Now, my lord, kindly come to the, my lord, section 4 notification issued. All the right of the intermediary from 1955 and all the right of the riot and under riot vested to the state in terms of section 4. I'm not placing the section 4. Kindly come to section 5 directly, my lord. And more precisely 5(1)(c). Subject to the provision of subsection 3 of section 6, every non-agricultural tenant holding any land under an intermediary and until the provision of chapter 6 are given effect to, every Rayat holding any land under an intermediary shall hold the same directly under the state as if the state had been the intermediary and on the same terms and condition as immediately before the date of vesting. Provided that if any non-agricultural tenant pays rent wholly in kind or partly in kind and partly in cash, then notwithstanding anything contained in the foregoing clause, he shall pay such rent as a revenue officer specially empowered by the state government in this behalf may determine in the prescribed manner and in accordance with the principle laid down in clause 2 of section 42. Provided further that any person aggrieved by an order passed by the revenue officer determining the rent under the first proviso may appeal to such authority and within such time as may be prescribed. Now, if we consider section 5C, a person holding any land under the intermediary, then from the date of vesting or chapter 6, that is for the Rayat and under Rayat, they will hold the land under the state. So, even if for the argument's sake, he is a Dakhulkar, if he failed to satisfy the point of the tenancy or the rent, in my humble submission, the state have a power to this under 5C to include the land held by a Dakhulkar into this as a vested land. Now, just now, kindly come to section 6. Now, section 6, there are, in my humble submission, there are two parts, because section 6 I am referring more precise point that a land under the ceiling limit hold in a 6.3 cannot be vested. Just to answer this particular question, I am referring section 6.3. Now, section 6.3 and notwithstanding anything contained in section 4 and 5, an intermediary shall, except in the cases mentioned in the proviso to subsection 2, but subject to the other provision of that subsection, be entitled to retain with effect from the date of vesting the land comprised in homestead, B, the non-agricultural land, Now, if your lordship consider 6.1c, find that there is a area has been described, how much land I can retain. Non-agricultural land in his khas possession, including land held under him by any person not being a tenant by leave or license, not exceeding 15 acres of acres in area and excluding any land retained under clause A. So, there is an area. Maximum I can hold 15 acres. Then, the agricultural land. In agricultural land, let you find that there is a specification of area that is 25 acres. Now, G is very important in our matter. 6.1G. Subject to the provision of subsection 3, land comprised in mill, factories and workshops. No matter my humble submission that section 6(1)(g) never restrict to any area or within the ceiling limit. So, my lord, section as Lordship finds section 1C or 1D, that is, my lord, the non-agricultural land, that's maximum outer limit has been prescribed. So far as the agricultural land is concerned, the outer limit has been prescribed. But so far as the mill and factory is concerned, there is no outer limit. Now, my lord,
subject to 3.
Subject to 3, that is 6(3). Subject to 3.
Yes.
Subject to 3. My lord,
What, sir? Opinion of the state government.
Opinion of the state government. My lord, if your lordship consider the reason behind the provision of section 6(3) or the reason behind, my lord, this enactment of the 6(3). My lord, this act enacted, my lord, in the year of 1953, when, my lord, the state just, my lord, our nation just get, my lord, the independence. At that point of time, just to promote the industry, this particular provisions has been made. The intermediaries' land, those were vested. Now, if there is an existing mill or factory, the state government on survey, if it is found that there is an existing mill and factory, just to retain the land and just to encourage this mill and factories, this particular endorsement was given. So reason behind the 6(3) is just not to retain land as homestead or, my lord, as a non-agricultural tenant. Now, my lord, kindly consider section 6(3) now. In the case of land comprised in a tea garden, mill, factory or workshop, the intermediary or where the land is under a lease, the lessee shall be entitled to retain. So, my lord, here
this is carved out as an exception of 1G, which clearly says that every factory mill will also vest.
Yes.
But only those portions will be excluded as per the exemption, which is ordered by the state government to be used for the purpose.
Lordship. Lordship.
So by default it vests.
By default it vests.
Everything.
But from
but Mr. Bhattacharya, if in the first place the ceiling limit is not, or you say there is no ceiling limit.
There is no ceiling limit. As in this present case, the land is, my lord, only 4 acres. But since it's a mill and factory, this ceiling limit, the concept of ceiling limit is not there. Only, my lord, the nature of the land. If it is a mill and factory, even if it's 1 acre, it has to be vested. The mill, factory or workshop, the intermediary or where the land is under a lease, the lessee. My lord, I'm just pausing for a moment. But you kindly appreciate the word lessee. Shall be entitled to retain so much of such land as in the opinion of the state.
This is or where the land is held under a lease.
Yes.
So in the case of land comprised in a tea garden, mill, factory or workshop, the intermediary. In that case, the intermediary will hold, and when the land is held under lease, the lessee shall be entered to retain. So this is universal for the intermediary as well as the lessee.
Lessee. That is the reason why I'm pausing for here. If your lordship taking the analogy from, my lord, the Non-Agricultural Tenancy Act, my lord, find the lessee. My lord, with deepest of respect, my lord, I say that I have gone through the judgment referred by my learned friend, my lord. In none of the case, my lord, this point has never been argued that the lessee also include lessee under the Non-Agricultural Tenancy Act.
Instead of operating in their favor, it would go against them if it's a mill or factory. Because you say, as per you, even the mill or factory held by the lessee also vests by default.
Yes, my lord, as per my understanding of this definition.
Universal. 1G is universal, subject to provisions of 3. Land comprised in mills, factories or workshops vest.
Now, my lord, this is explained in explanation 1 also. I'm coming to that. In the opinion of the state government,
No, but there is something else. Mr. Please come to section 6, the beginning of it.
non-obstructive
Qualifies, no, not only non-obstructive. An intermediary shall, except in cases mentioned in subsection 2, but subject to be entitled to retain with effect from the date of vesting this disease. So it's an intermediary who is entitled to retain. So therefore, G has to be read with
now, my lord,
intermediary,
another,
not the lessee.
Another interesting part. Maybe, my lord, I'm wrong, my lord, but for the academic purpose, my lord, I'm just referring. My lord, if your lordship consider section 5.1c read with, my lord, section 5.1c. This year. 5.1c, the intermediary until the provision given effect to every right holding land under intermediary shall hold the same under the state as if state has been intermediary. So, my lord, I may be wrong, my lord, but in my understanding, my lord, this 5.1c has been drafted in such a manner, my lord, any land which is recorded as mill and factory, my lord, has been left out. I maybe, my lord, is absolutely, my lord, my understanding, my lord. But if you read, my lord, 5.1c with section 6.3, my lord, any land which is recorded under mill factory that is vested to the state, irrespective of, my lord, whether it's a Dakholkar or not.
But the non-agriculture, as per 5.1c, non-agricultural tenant holding any land under intermediary becomes direct. It vests in the first place in the state, but the non-agricultural tenant then remains. If 5.1c is read with 6.3,
yes,
then as per your interpretation, apparently it will be that if it's 5.1c says it vests in the state, you become a direct tenant under the state. And 3 says in the case of land comprised in a tea garden mill factory, the intermediary, or let us come to the second part.
Yes.
Where the land is held under a lease, the lessee shall be entitled to retain only so much of such land, as in the opinion of this. So here this equalizes an intermediary with a lessee.
My lord,
It will be a contradiction in terms.
My lord,
because then the lessee's property also vests.
My lord, here, as my lord, as I understand, here, my lord, the lesser is the state. Kindly put, my lord, the state as a lesser.
No, it is not qualified. Or where the land is held under a lease, the lessee shall be entitled to retain only so much of such land as required for that purpose, and the person holding under a lease shall, for the purpose of assessment of compensation, be deemed to be an intermediary. Very good. For the purpose of assessment of compensation, if he is deemed as an intermediary, and not for anything else, then a lessee cannot be equated with an intermediary for the purpose of vesting.
No.
So this read with 5.1c says, apparently, that if it's a lessee, becomes a lessee directly under the state.
My lord, the lesser is the state.
State becomes the lesser, even if it was there was an intermediate lesser. Because it is unqualified, is held under a lease. The lessee shall, but
Be
then
entitled to retain only so much.
But
of
then
the
what
land?
happens? The lessee will also retain only that much of land. Suppose it's a leased property, let out property, lessee are there. State government does not hold anything to be required for mill factory. Then what happens? It automatically vests. Then the mill factory, this paradigm does not apply at all. If that be so, if it's not opined by the state government to be a mill used for a mill or factory, then it's a normal property. It goes to the normal pool. It's not a mill or factory.
Well, if we consider section 6.3, there are 2 or 3 ingredients. Number 1, the land held by an intermediary. Number 2, the land used as a mill or factory, or would be used as a mill or factory. Number 3, the opinion of the state government. As 6.1 or 6.1 2, there is no automatic retention. Here, the
It's the other way around.
Yes.
It's automatic vesting.
Here, vesting is automatic, Retention is at the opinion of the state government.
So for factory mill, etc., it's a different structure altogether.
Absolutely, my lord, as I find, my lord.
Unlike the other characters of land, these automatically vest. Tea garden, this is vest in the state.
61G, my lord, will operate.
So all these tea gardens which are retained were
All the
these orders were passed.
Yes.
The tea gardens which you see in West Bengal.
Those are, my lord, all vested, and, my lord, a deed of lease was executed by the state in favor of these lease tea gardens. Now, my lord, kindly see the explanation. The explanation: land held under a lease includes any land held directly under the state under a lease.
Inclusive.
Includes.
It may exclude also.
It may exclude.
There may be others also held under
Correct.
different lease.
Now, my lord, another portion. Now, my lord, I'm sorry, my lord, I'm forget to, my lord, place, my lord, 6(2) also is relevant, my lord. An intermediary who is entitled to retain possession of any land under subsection 1 shall deem to hold such land directly under the state from the date of vesting as a tenant, subject to such terms and conditions as may be prescribed and subject to payment of such rent as may be determined under the provisions of this act and as entered in the record of right finally published under the chapter 5, except no rent shall be payable for the land referred to clause H or I. Now, let this proviso, provided that if any tank fishery or any land comprised in a tea garden, orchard, mill, factory, or workshop was held immediately before the date of vesting under lease, such lease shall be deemed to have been given by the state government on the same terms and condition as immediately before such date, subject to modification therein as the state government may think fit to make. Then, my lord, I think, my lord,
And 3, the subsection 3 also contains the answer to a question also. It actually equates lessee with an intermediary. Be deemed to be an intermediary.
My lord.
So that question is answered here only.
So, my lord, if we
So
consider,
lessee is put on an equal footing as an intermediary.
my lord.
And it vests.
So, my lord, if we consider, my lord, Non-Agricultural Tenancy Act as well as, my lord, this Estate Acquisition Act, we find, my lord, that to be a non-agricultural tenant, mere recording of a dakhalkar, my lord, would not serve the purpose. You have to establish, my lord, that I am holding a land under a, my lord, tenant or, my lord, or someone else. So, my lord, from state and, my lord, this non-agricultural tenant, there should be existence of someone. And, my lord, the payment of rent. These two are, my lord, what I say, my lord, the demand of the act. So, Dakholkar,
What about the judgments which say that Dakholkar is not?
my lord, this judgment, my lord, has in all the judgment, my lord, what I my learned senior place, my lord, there it has been stated that non-agricultural tenant are outside the purview of the EA Act. I'm not, my lord, I'm also, my lord, on this.
1 or 2 judgments say that Dakholkar is non-agricultural tenant.
My lord, my lord, this point has not been raised that to be a non-agricultural tenant, there are some other criteria. I must say, my lord, this Dakholkar, the definition Dakholkar is a non-agricultural tenant. It may be a illustrative, but not an exclusive.
Dakholkar may or may not be.
Maybe, my lord, he may be a non-agricultural
Particular
tenant.
case.
Now, my lord, kindly, I'm just now, my lord, placing, my lord, some of the portion from the writ petition. My lord, kindly come to page 119 of the writ petition. My lord, the first important thing is, my lord, the date. This property transferred in the year of 1962.
Hmm.
So the petitioner before your lordship are the post-vesting transferee. And my lord, this is
If there was a vesting in the first place.
my lord, as apparent, my lord, from the recording of my lord, the record of right, my lord, it prima facie says that land was vested to the state and there is a recording of the 60. So they are the post-vesting transferee. And if your lordship consider, my lord, from the recital of the entire deed, I've gone through this deed, my lord, I'm not my lord, wasting the court's time to reading the entire deed. But my lord, from the recital of the entire deed, I find nowhere it has been recorded that there is a supertenant and the land held by my lord, the predecessor as a my lord, tenant as a lessee, or there is any whisper as regard the payment of rent. And if your lordship consider page 137 of the deed, my lord, find the record land is the nature of the land. Those are Lakheraj, Malik, and Dakolkar. So far as Malik and Lakheraj is concerned, my lord, I can show to your lordship, my lord, that they are the my lord, class 2 intermediary. আমি নিয়েছি জেরক্স করে নিতে দেখাচ্ছি
ওটার কোনো ভ্যালু নেই ওটা কি গভর্নমেন্ট অফ ওয়েস্ট বেঙ্গল কোম্পানি 1917 অ্যাক্টের গার্ডেন গ্লসারি অফ 1917 পাবলিশড বাই
The very next page is also Malik, Dakolkar, Malik.
And Lakheraj.
And my lord,
Last one. Left. We'll continue with this. We'll take up the 2 p.m. matter, we have fixed a matter, and then continue with your matter.
Right.
Yes, Mr. Bhattacharya will just continue. Yes.
Lord, I appear for the plaintiff appellant, my lord. My lord, appeal against an order refusing grant of an identity order of injunction, my lord. Now, my lord, I was the erstwhile director and the guarantor to the credit facilities, my lord, extended by the defendant number 1 bank in favor of defendant number 2 company. Now, my lord, kindly takes, my lord, the first annexure, which is at page 17 of my IA, of my lord, the CAN, wherein, my lord, it records that I had sought, my lord, to resign as a director. However, this honorable court holds that my resignation or the acceptance of my resignation will not be construed to mean a discharge of any subsisting guarantee. So I continue to be a guarantor. Now, my lord, kindly takes up page 19 is the order passed by the DRT. Now, my lord, the company, meaning they have a defendant number 2, files, my lord, a section 17 application before the DRT. The DRT, my lord, kindly now takes page 24. The DRT holds that the account was wrongly classified as an NPA. DRT holds this, my lord. Now the bank goes in for appeal. In the appeal, my lord, I make an application for impleadment. Impleadment must not allowed, my lord. That would be at page 25.
Section 17.
No, I was not party to section 17. So 25, my lord, I seek page 25 is the order, my lord, wherein my application for impleadment was rejected. My lord, I come before this honorable court. Page 28 and page 30 are the orders, subsisting orders of, my lord, stay of the proceedings of the DRAT. So, my lord, the appeal is pending before the DRAT. My lord, the order that the account was wrongly classified as an NPA is still subsisting. Now, my lord, what the bank does is, my lord, now takes up page 31. The bank floats a notice, web notice, at page 31, my lord.
1 second, just. Yes.
Kindly sees, my lord, in terms of the bank's policy on transfer of stress loan exposure in line with the regulatory guidelines. So, my lord, this is a sale under the RBI guidelines. Now, my lord, kindly sees, there's, my lord, this chart box, my lord, kindly sees SAM 2B, second entry, my lord, serial number 2. Kindly sees the name of the unit, Devi Ispat. Devi Ispat, my lord, is the second defendant. So, my lord, I challenge the propriety of this web notice because I say that this sale under the RBI guidelines could not have been effected if the account was not an NPA. I file a suit. Kindly takes, my lord, the suit at page 41 and the reliefs at page 48. The reliefs are at page 48, my lord. I challenge.
Notice was under section 13 too.
No, this notice, my lord, would kindly see it was the RBI under the RBI guidelines. In terms of the bank's policy on transfer of stress loan exposure in line with the regulatory guidelines, we place the following two accounts. So, my lord, SARFAESI Act is not a notice under the SARFAESI Act. It's a notice under RBI guidelines. Now, my lord, I file a suit, my lord.
That notice is not annexed here.
Yes, my lord. That is notices, my lord, page 31.
Oh, this is the notice.
This is notice, my lord.
Right.
The first line says it's a notice under the RBI guidelines.
No, it does not. Does not say so.
Yes, my lord. In terms of the bank policy on transfer of stress loans, in line with the regulatory guidelines, my lord. So it's not a sale under SARFAESI Act. It's not a sale under 13(4). So, my lord, it's under the RBI guidelines. Now, my lord, I file a suit. The reliefs are at page 48. I challenge the propriety of the web notice. Page 48 is my prayers, my lord. My lord, in connection therewith, my lord, I seek an order of injunction. That's page 60.
Yes.
This is the order, my lord. Restrain defendant number 1, main and agents from transferring loan exposure. Now, my lord, kindly comes to the impugned order, my lord, which is annexed to the memo of appeal. The memo of appeal, my lord.
Yes. This is not yours.
This is the can, my lord.
Yes.
The last paragraph of the first page. my lord.
Hmm.
Here, I would like to mention that after declaration of NPA, the matter was referred to DRT. Hence, being dissatisfied with the order of DRT, the appeal before DRT has been preferred. Some order has been challenged before the Honorable High Court, where Honorable Court has stayed the proceedings relating to that matter. If a matter is pending before the DRT and Honorable High Court, then plaintiff must prove regarding any subsequent change circumstances before those two forums and not before civil court. Anyway, any matter relating to Surface Act must be dealt with DRT and 34 of Surface.
There's no caveat.
No caveat.
The present appeal has been preferred against an order whereby the ad interim prayer of the appellant was refused. Full stop. Next para. The appellant is a guarantor in respect of a loan advanced by the respondent number one bank to the respondent number 2 stroke borrower. Full stop. Next para. In connection with the same comma, a notice under section 13 within bracket 2 of the Surface Act was issued to the borrower, comma, which was challenged by the borrower before the Debts Recovery Tribunal. Full stop. The Debts Recovery Tribunal set aside the said notice on the ground that the declaration of the account of the borrower as NPA within bracket non-performing asset bracket closed was bad in law. Full stop. Being aggrieved, comma, the respondent number 1 bank has preferred an appeal which is now pending before the Debts Recovery Appellate Tribunal. Full stop. The present appellant sought to implead itself as a party to the appeal which was refused by the Appellate Tribunal, comma, against which an appeal was preferred by the appellant.
My lord, revisional application. My lord.
Sorry, revisional application was
Page 28.
That's right. Preferred by the appellant. Puts up next para. In connection with the said revision, comma, the all further proceedings of the concerned appeal bearing appeal number 99 of 2016 has been stayed. Full stop. Next para. The revisional application, comma, we are apprised, comma, is still pending. Full stop. Next para. Meanwhile, comma, the present suit, comma, from which the current appeal arises, comma, was filed by the respondent assailing a notice dated July 10, 2026.
That page, it's July 10, 2026.
Yes, July 10, 2026, as well as seeking consequential reliefs. Full stop. An injunction application was filed in respect thereof, comma, wherein the ad interim prayer, comma, which has been refused by the impugned order, comma, was also sought. Full stop. By the impugned order, comma, the learned trial judge has refused to grant injunction on the ground that the matter is pending before the Debts Recovery Appellate Tribunal and the honorable and this court, and the plaintiff stroke appellant must move regarding any subsequent change of circumstances before those two forums and not before the civil court, comma, also invoking the bar under section 34 of the Surface Act. Which of next para, it is argued that the bar under section 34 is not applicable at all, comma, since the suit has no connection whatsoever with any measure taken under section 13 of the Surface Act, but is an independent challenge to a notice issued under in terms of the bank apostrophe's policy on transfer of stressed loan exposure, comma, in line with the regulatory guidelines of the Reserve Bank of India. Full stop. Next para. Moreover, comma, it is submitted that there is no question of approaching the Debts Recovery Tribunal and stroke or this court in view of the matters pending before the said forums being unconnected, having no direct connection with the cause of action for the suit. For sub next para, we find prima facie, we find substance in such contention. For sub accordingly, the appeal is admitted to be heard on the above question and the other grounds taken in the memorandum of appeal. Full stop. Next para. The appellant shall serve copies of the application and the memorandum of appeal, along with all annexures on the respondents, indicating that the application shall be listed for hearing on September 14, 2026. When an affidavit of service in that regard shall be filed by the appellant. Next para. The respondents shall remain restrained by respondents and or their men and agents shall remain restrained by an order of injunction from taking any coercive steps and or only coercive steps.
No, prayer is at page 14, Malord.
Yes,
because if they succeed,
petitioner's person status classification.
No, Malord, I'm not what. Kindly text page 14 of my injunction application before the appellate court, Malord. Before this court, Malord.
So these steps or further steps?
I would say, Malord, not to confirm.
Coercive steps regarding that notice only. Only that much. No coercive steps in respect of the notice dated July 10, 2026, which has been assailed in the suit, bearing title suit number 1786 of 2026, pending before the 6th bench of the City Civil Court at Calcutta till disposal of the application.
But what I'm a little apprehensive about, Malord, is that the sale was on 5th. Now, if they confirm the sale, Malord, the coercive steps will not have any, Malord, bearing, Malord. So, Malord, they subject to correction.
That has taken place.
5th, but kindly sees, Malord, the web notice at page 31. After the sale, Malord, kindly sees paragraph number 3 at page 31. After completion of the e-bidding process, further negotiations with the highest bidder may be done by the bank based on which the recommendations for transfer of stress loan exposures will be put up before the competent authority. So, Malord, it has been put up before the competent authority. Malord, I've told the competent authority has not sanctioned this as yet.
So, what sort of injunction do you want?
Not to take any further steps with regard to this, Malord, sale.
And or and or from taking any further steps in respect of the sale, if any, held in terms of the said notice.
That would suffice. I'm so grateful, Malord, so grateful. Malord, I'm carrying the master.
Did it ask you to?
No, this is first time, Malord. It could come on. It's not. And Malord, this should have appeared on the heading Order 41. Because the first time the matter is coming up, Malord.
It is appearing as what?
Application.
Huh? Thank you.
I'm grateful, Malord. I'm so grateful.
Continuing. Have you taken out copies of the glossary?
No, Malord, as I placed, Malord, the copy of the deed, which is at page 119.
Yes.
Now, Malord, first, Lordship kindly mark, Malord, the date. That is 1962. So the petitioner is the post-vesting purchaser. And Malord, the proceeding initiated for 6-3, perhaps at that point of time, the petitioner was not, Malord, the petitioner's company was not in existence. The predecessor or in interest of the petitioner's company, they were there. Now, I'm just placing 2 or 3 lines from the deed. Kindly come to page 120.
Yes.
At the last line from the bottom. Whereas the said Aaron Calendar, Moses Calendar, David Calendar, Joseph Calendar, Mia Calendar, and Rachel Calendar had for a long time carried business on a business in a co-partnership under the name and style of Nesas S. Calendar and Company in West Bengal. Now, the deed starts with this. The recital says that they are running a business, but there is no whisper under whom, who are their superior landlord, whether they are paying any rent or not. Those are remain silent in the deed. Now, 4. Same page, 121, paragraph 4. By diverse deeds, all those messages, land, building, hereditament, and premises, together with factory sheds, godown, warehouse, pump house, powerhouse, railway siding, and all other erection hereinafter more fully described in the first schedule hereto, together with fixture fittings, movable and immovable, were commonly known as Bali bone mills and or Ganges Valley bone mills and or Bali Khal bone mills, hereinafter collectively referred to as mill property. So, in 1962, there was an existence of mill. Now, if your lordship kindly consider the definition as we shown to your lordship under 5(1)(c) and 6(1)(g, one of the paramount criteria that as on the date of vesting, there should be a mill or factory running at the said premises or at the said property. So, the first criteria has been fulfilled, that there is a mill factory running in the said property. Now, my lord, I'm placing the glossary. Page.
And it also says that it was those were acquired and or purchased and are assets of the partnership. So cannot be a tenancy in that sense.
Lordship. So I can understand, my lord, if there are something, you may have no document to show that rent receipt or something, but there should be some reference in the deed. Since he is a post-vesting purchaser, there should be some reference under whom his tenancy created.
He may also pay rent directly to the state.
But direct to the state, but those were from 1953. Prior
No document is shown in that.
Nothing, nothing. There is iota, no iota of document to show the tenancy or even a single rent receipt or the statement. There are 3 criteria.
All right.
Now, kindly come to page 20 of the glossary.
Yes.
17
at the top, landlord. Malik, Muni, Bhu Muddhadhikari, Khajna Prapok, Raja. Now, 20. Now, this can be read with page 39. Page 39, item number 5 from the bottom. Malik proprietor. So Lordship, kindly consider the definition of intermediary, my lord. It includes proprietor. Now, page 22, rent-free. My lord, this is also, my lord, item fee from 5 from the bottom. Nishkor, Lakhiraj, Shebottor, Brahmottor, Devottor, Pirottor, Moharan, Chiradi.
And also revenue free.
And this is revenue free.
That takes care of state.
And this is, kindly read with 42, page 42, Nishkor, second from the top. Nishkor, rent-free. In the record, denotes valid rent-free grants. So, my lord, so far as the Malik and Lakheraj is concerned, they are, my lord, chapter 2 intermediary. Now, my lord, it may, my lord, come up in, my lord, the question may arise that what is then the status of Dakholkar? Now, my lord, my understanding, my lord, considering, my lord, the provisions of the Non-Agricultural Tenancy Act as well as, my lord, the Estate Acquisition Act, this word Dakholkar used in the record of right as conditional retainer who was allowed the possessory right, my lord, as a Dakholkar. My lord, Dakholkar, my lord, is a common meaning, my lord, a possessory right. So, my lord, a conditional retainer who was allowed a possessory right under the state to run a factory and mill. That is a specified purpose. The land was given to retain as a possessory right.
Is it mentioned Nishkor somewhere?
No, my lord, Nishkor is there, my lord. Nishkor is
in the records of rights.
Yes, yes. My lord, Nishkor is there, Lakheraj is there, and Dakholdar is there. There are 3 categories. So far as Nishkor and Malik is concerned, from the glossary, I can straight away show, my lord, that this come to chapter 2 intermediary, my lord. So far as the Dakholkar is concerned, there is this glossary remains silent about Dakholkar.
But there is a definition at page 31.
My lord.
Please correct me if I am wrong.
Page 31.
My lord,
Have you found it?
yes, yes, yes. Yes, definition is there.
Silent.
Page 31, Dakholkar
With an interest.
is an occupant. Also possessor of an interest. I'm grateful, my lord. I missed this.
I'm also grateful. Never used in the case of a tenant according to section 4 of the Bengal Tenancy Act. Right hand. Remarks today.
Never used for it. Never in case of tenant. According to section 4 of the Tenancy Act.
একটা বের করো এই ব্যাগটাকে ওদিকে রাখো না একটা বের করো বড় বড় বড়
So, my lord, considering, my lord, this endorsement Dakholkar in the RS record of right, as we, my lord, understand, my lord, that this is means that it's a conditional, my lord, the applicant or the petitioner is a conditional retainer, my lord, having a possessory right under the state to run the mill and factory. Now, my lord, this, my lord, there, so, my lord, so far as the first 2 question is concerned, whether the petitioner is a non-agricultural tenant or not, my lord, from the record, my lord, there is no, my lord, document which shows, my lord, that there is a tenancy or, my lord, lease or, my lord, there is even in a rent, my lord, rent receipt. So, my lord, we can, my lord, conclude, my lord, that he is not at all a non-agricultural tenant within the meaning of Non-Agricultural Tenancy Act. So far as, my lord, the Dokholkar is concerned, my lord, he is an occupant, my lord, he is possessing the same, but as a conditional retainer, considering, my lord, the endorsement of 6.3 under the state to run, my lord, the mill and factory. Now, my lord, so far as the third point is concerned, that is whether, my lord, the petitioner's case is barred by, my lord, the principles of estoppel or not. Now, my lord, from the supplementary affidavit as well as from, my lord, the
এইটার দুটো এক্সট্রা কপি করে দিন, করিয়ে নিয়ে এরকম মানে বেঁধে একটা ওনার কাছে একটা আমার কাছে glossary।
yes. And there is another glossary, that is Touji glossary.
We are waiting for an opportunity to usurp it.
My lord, kindly come to page 211, which is the record of right. The legible copy is
Yes.
ওর মধ্যেই আছে। তাহলে আমি রিট পিটিশনের
দখলকার
মালার as well as malar, there is an endorsement that the land was retained under 6.3. There is a proceeding number and the date. Right. Malar, the legible one is 215. In malar, as I malar gone through malar several endorsement, in all 6 malar recording, these endorsements were given with a with a L, capital L dash ref. These are the number which was given in this all the 6.3 endorsement. Next one is also same, my lord. In all the record of right, this Dokholkar and my lord, page 219, I find, my lord, that there are Suomoto 44 2A proceeding initiated. 219, my lord, find, my lord, that 44 CS record corrected. শ্রেণী সত্ত্বের শ্রেণী ও বিবরণ দখলকার, দেন my lord, find, my lord, Suomoto.
What is this 44 2A?
Yes, my lord. Suomoto under section 44 2A. Then, my lord, 464. 464 maybe, my lord, there is some serial number or something is there, but
It is repeated anywhere else in any of the other records? 219, this. Yes, page 225 also, and 223 and many
Yes.
other pages.
it may be, my lord, serial number, right?
Yes.
So, this 6.3 recorded in a proceeding under section 44 2A, there is a specific date I find, my lord, and also the reference number. Now, if any person is aggrieved by the order of 44.2, your lordship knows, my lord, that there is a provision under 44.3 to prefer an appeal. He has not preferred this appeal under section 44.3. Now, my lord, in the Non-Agricultural Tenancy Act also, there is a provision under section 28, which is related to the draft publication and final publication of the record of right. Now, if anyone is aggrieved by the wrong recording as a non-agricultural, for the sake of argument, I admit that he is a non-agricultural tenant. When the Non-Agricultural Tenancy Act, the record of right corrected, there is also a provision under section 28 to challenge, my lord, this recording. Though under, my lord, 44.3, but invoking the provision of section 28. That was not even done. Now, my lord, my point is, when the principal order is not challenged, the person cannot challenge the same in any subsequent or ancillary proceeding. But in this core, I am referring two decisions. Sir, আমার কাছে আমি এই কপিটা দিয়ে দিচ্ছি আপনাকে। মানে this is unreported decision. I'm handing over the copy to my senior, my lord. WPLRT 733 of 2004. My lord, second page from second paragraph. On a bare reading of the impugned order, it appears that the original application petitioner challenged the notice issued under section 10(2) of the West Bengal Estate Acquisition Act 1953 for taking delivery of possession of the vested land as was not retained by the bequeather. The petitioner challenged the notice on the ground that in the notice concerned act has been mentioned as West Bengal Land Reforms Act and not the West Bengal Estate Acquisition Act. Learned Tribunal held that such mistake cannot be a ground to challenge the notice. Learned Tribunal further has discussed the legal point that when the original order of vesting is not under challenge, there is no scope to challenge the notice. It is settled law that if the basic order is not challenged, but a consequential order is challenged, the application is not maintainable. It is a legal obligation to challenge the basic order, and if it is found wrong, consequential order may be examined by the court to test its legality. Reliance, then the several Reliance was placed in support of this proposition. In this particular case, my lord, the recording of the 6.3, the order recording 6.3, my lord, the retention order, that has not been challenged. What is challenged here? The consequential order of conversion. So, my lord, my humble submission that if the 6.3 order, retention order under section 6.3, that has not been challenged, the subsequent order cannot be maintainable. And my lord, the second part is, sir, second one is 2020 volume 6 SCC page 387 paragraph 26 and 27. আমি কপি দিয়ে দিচ্ছি আপনাকে।
volume 6
It is also not disputed that the plaintiff and defendant number 1, 2, 3 herein filed a suit for eviction of an occupant in which he claimed paragraph 26 and 27.
We don't have to tell the basic order.
Rather, 27 is the more relevant. The doctrine of election is the facet of law of estoppel. A party cannot blow hot and blow cold at the same time. Any party which takes advantage of any instrument must accept all that is mentioned in the said document. It would be opposite to refer the treaty's equity.
How is this relevant?
Well, this is relevant.
The
Just
deed.
estoppel, my lord. He has not challenged, my lord, the earlier order. So, my lord, the second order.
This is on the doctrine of election in the sense that you have accepted benefit under a will, under a deed, you cannot go against it.
Well,
You have to follow all the provisions.
6.3, my lord, intermediary, land of intermediary.
That is general principle of estoppel.
Lordship,
under the
that
general
is,
law.
that is it.
But this is not applicable in terms. This says if you have accepted under a particular deed, you have to accept everything in the deed. Not take advantage, not choose the advantageous portion and the discard the other portion. This is directly not applicable. Anyway, we are taking it.
Now, my lord, the secondly, my lord, so far as my lord, my contention is that since my lord, they have not challenged the basic order, the consequential order, challenging the consequential order, that is not maintainable. This is my lord, third point, and my lord, my last point is the whether my lord, the order of conversion that is maintainable or not. Now, my lord, if your lordship kindly consider the conversion order, which is part 2 of the writ petition, that is at page 144.
Your point is whether conversion?
Conversion order is without jurisdiction and maintainable in the eye of law.
This will be page?
Page 144, this order of conversion. I am referring page 45.
145.
145, 145.
144 and 145.
My lord, kindly consider, my lord, point number 4. So, my lord, there is a savings clause. Even if this conversion order was my lord, passed, this is without prejudice to the provision of subsection 3 of section 3. And my lord, lastly, this my lord, section 4C, that is applicable to Rayat. 4C of the Act, that is applicable to Rayat. No, ওটা ওই আগেটা আপনি দিতে পারেন আমাকে। 4C. Because section 4C1 start with the word or Rayat. Four C of the West Bengal Land Reforms Act.
Okay. Oh.
Because this permission granted under
yes, conversion. Yes.
Kindly see 4C1. This section start with the word or Rayat holding any land. So if I have to take the benefit for conversion under section 4C, first I have to satisfy that I am a Rayat.
4C1. But Rayat definition is given as a person in this act.
Yes.
A person or an institution holding land for any purpose whatsoever. Very vague. I mean, maybe the
yes, madam.
Rayat under this act, we have to say Rayat under this act.
Yes, but here,
so all the rungs of intermediaries are also covered by this. Broadly, I mean, argue to the contrary. We are inviting you to argue on this. Rayat means a person holding land for any purpose whatsoever. So holding land.
Now, my lord, holding land or my lord, a person retaining land as a lessee or as a my lord,
Read something into this definition because this Rayat in 4C is
yes, my lord, that is there, my lord.
guided by this definition.
Rayat means any person or institution holding land for any person whatsoever. So, my lord, the basic right as per this act,
Even the lowermost person who is
if a
not
person
the
hold land, he is a Rayat.
that is also covered.
Yes. Now, my lord, what I am trying to satisfy, my lord, that he is not a Rayat. Rather, he is, my lord, a conditional retainer for a specific purpose. So, my lord, the order passed by the authority that is without jurisdiction. And, my lord, this order of the tribunal, my lord, is absolutely, my lord, on the basis of available records.
Yes.
Lord, I am not going to some academic discussion with regard to the scope of this, etc., or this. Lord, my principal submission will be that what I have stated there, two aspects I must point out, very lordships, that endorsement regarding 6.3 of the Act subject to section 6.3. Your lordships kindly have a look into section 3 once more. First of all, this 6.3, it is section 6 heading right of intermediary to certain lands. Kindly look, not 6.1. So he must be intermediary first of all. Government is required to say, in order to apply 6.3, that he is an intermediary. On the basis of records produced, records of right, in respect of very small quantum of land, that is Malik or rent-free land, Lakiraj land, entire lands is recorded as Dakholkar. I will come to Dakholkar. Now, in case of still then mere intermediary, how this is to be done and how this endorsement has been made and what is the precondition of this. In case of land comprised in a tea garden, mill, factory or workshop, the intermediary, or where the land is under a lease, but here the question of lease doesn't arise. We are not saying that we are holding under a lease. The lessee shall be entitled to retain only so much of land as in the opinion of the state government is required for tea garden, mill, factory or workshop as the case may be, and a person holding under a lease shall for the purpose of assessment of compensation be deemed to be an intermediary. So what is important is that government, in the opinion of the government, is required for mill, factory or etc., etc. So it presupposes that there must be an order under section 6.3. Without order under section 6.3, no endorsement can be made in the records of rights subject to retention. I could have understand that revisional records of right was prepared on the date of vesting. I am not disputing that, but their order in 67 speaks of that they decided the case in respect of the purchaser. That is absolutely legal.
On the basis of the?
On the basis of the purchase made by the petitioner. That is that order is nowhere here. Your lordships can't see, we can't see. But from the observation of the tribunal, we find that it was the finding of the tribunal that this applies, this was decided in the context of purchase made by the petitioner. But be that as it may. Now, my lord, when this endorsement is made, then there must be an order under section 6.3. Where is that?
They referred to the date of the order and number.
No, that your lordships kindly see in a 44-2A proceeding, right of retention or right land to be
No, section 6.3 order is referred to by the date and the number of that matter.
No.
Yes. Just now, Mr. Bhattacharya, please. 211, 215. 211, 215. All those pages.
Then, my lord.
Have you found it? 211, 215?
Yes, 221. 200.
No, not 211, 215.
Yes, 211.
And 15, right hand column.
Yes. My lord,
215 may be more legible to you.
Yes.
Almost.
Three dharamate rokito.
And they've given a number before the date and number.
If it is so, then, my lord, treating him as intermediary, this was written. And, my lord, if it is allowed to be written, then, my lord, the entire land was allowed to be written. But only 4 point something acres of land. Even under Rule 4, West Bengal State Acquisition intermediaries are not required to file any option form if the land held by them is below the ceiling limit.
But then your other argument goes, if you are an intermediate.
No. I am not. This is my second limb of submission, my lord. Always I have 2 limbs of submission. But the Kholkar, my lord, I am coming to that, my lord. So, my lord, I say, my lord, this order we did not see, but even if it is deemed to be correct, that he was deemed to be an intermediary which they cannot do. As a Dakhalkar is never an intermediary. So, my lord, this endorsement is on the face of it wrong because the petitioner or his not the petitioner, because his predecessor in interest was not an intermediary.
Mr. Bhattacharya raises an issue, the issue of estoppel also, the principle of estoppel. If you have not challenged the 6.3 order or the 44-2A.
This is the endorsement here. Now, my lord, I say this is my learned friend
did not challenge.
Yeah. No, we have not challenged in 44-2A, but 44-3A, but the scope of 44-2A is not to decide the quantum of land which can be allowed under section 6.3. 44-2A comes, kindly read 44-2A. It is completely for revision of records of right, finally published.
No, his argument was that 44-2A you did not challenge because you should have challenged the recording as these recordings. So these recordings you have all admitted.
No, what I am saying, Lord, this is without jurisdiction because this doesn't apply to intermediary. If it is without jurisdiction, your lordship knows your lordship knows several decisions. If on order it can be challenged in a collateral proceeding. It can, if it is without jurisdiction.
All right.
Other points.
So jurisdiction would come in only if you succeed on the other ground.
On the other ground. Then, my lord, deed, etc. I am not saying that. Now, my lord, reference to WBNA Act, my lord, retention order not challenged, that I have shown to your lordships. Now, that your lordships has pointed out that so far as Bengal Tenancy Act is concerned, my lord, I think there is no separate definition of intermediary. They are in these classes of tenants, as section 4 my learned friend referred, that, my lord, the completely page 31, those are not coming within this Dakhalkar. Your lordship has pointed it out. So, these Dakhalkars are not coming under the definition of 10-year holder or intermediary or like that. Or the Rayat, my lord, doesn't come in because Rayat only in respect of agricultural land. And so far as other lands are concerned, 10-year holder, etc., etc., etc. So, they are excluded from the definition of tenant as provided in section 4 of the section 4 of the Bengal Tenancy Act. Then, my lord, your lordships, another one point, my lord, that so far as clearly excluded, the Holkar is clearly excluded from the definition of tenant, and the definition of intermediary as provided in the West Bengal Legislation 2Y, that the intermediary, tenure holder, etc., those classes of tenant referred to in paragraph 4, section 4. And so far as the other tenants in the same subsection 2 of that part, they are in the riots, under riots are defined, they relates to agricultural land, and those were included by subsequent amendment of 1956, chapter 6 come into operation of the West Bengal Estate Acquisition. This is the next more important question is this, that my learned friend has said that without prejudice, section 6.3, that is not required to be developed. I have said this is without jurisdiction. Lastly, my learned friend has said that only riot can apply for conversion. Only riot can apply for sanction under section 4C. By virtue of 1981 West Bengal Land Reform Amendment Act, by virtue of which the non-agricultural land were given the status of riot under subsection 2. So by virtue, in the meantime, after purchase in 1981, the petitioner became riot. So they have every right to apply for conversion of the land. And your lordship has seen the definition of riot also, it includes everything. So there is no illegality in applying for conversion of the land. Even under this this survey act, the Dakhalkar has been kept outside the definition of tenants that are provided in sector. So Dakhalkar, and the point at the cost of just repetition in one sentence. Number this scope of West Bengal Estate Association is very clear. That only rights of intermediaries, rights under rights will be vested. Their rights will vest, and what land will vest, the estate hold by them. So land will vest, along with the land, the rights of intermediaries or the tenants, etc., under what has been defined in the two things will vest. Estate will vest, hold by them, and their rights will vest under the act. And my lord, as prepared by their own showing in the RS records of right, the petitioner have been shown as the Dakhalkar. What, and your lordship have since 39, for the purpose of carrying out this provisions of this act, the records of rights shall be prepared. Now it is under them to prepare it, not under us. They are to ascertain on the basis of earlier records of right, that is CS records of right, a person, what are the quantum of lands held by them, whether they should be classified as an intermediary or rights or under rights. It is absolutely upon the government to prepare the records of right, and after that, on the basis of recording made in the RS records of right, then the vesting proceeding will be initiated. If it is within the ceiling limit, no question of return shall arise, it shall be allowed to be written. And my lord, if it is beyond the ceiling limit, then the options are to be filed. In case of intermediary, of course.
So Bhattacharya has made two other arguments.
Yes.
Very important arguments. One is that under section 6,
yes,
whatever is provided there, by default, if it's a factory or mill, and if there is no opinion of the government,
yes,
then it vests in its entirety. That is how Mr. Bhattacharya sought to interpret section 6.3 read with section 6.1. Because 6.1, according to, yes, 2.1G also, right? 2.1G also.
Yes, 2.1G is to be read along with 6.3.
Yes,
yes, no doubt, 2.1G.
2.1G, 6.3, and also 6.1 itself. I mean, because as per 6.1 itself, notwithstanding anything contained in 4 and 5, an intermediary shall, except in cases mentioned, be entitled to retain with effect from the date of vesting such and such land. So, by necessary implication, if this and it's included, G includes land comprised in mills.
Yes.
Subject to 3.
Yes. subject to 6. So, my lord,
Yes. And there is no ceiling limit here.
yes.
This
So,
is
my lord,
right. Justice they rightly points out, as argued by Mr. Bhattacharya, 6(1)(c) there is a limit, 15 acres. Various other provisions, D also has a limit, but G has no limit, 6(1)(g). So you are entitled to retain subject to provisions of subsection 3. And subsection 3 clearly says, in case of land comprising such and such, shall be entitled to retain only so much of such land as opined by the state to be required for the purpose. Clear. So only so much of land. If there is no opinion, then what happens?
then we will.
The entire thing should vest. That is his submission.
No, if there is no opinion, my lord, that, my lord, subject to, my lord, the two things have to be.
Because the language is only so much.
I understand, my lord. My lord, two things have to be considered. One is vesting. My lord, so far as rights of intermediaries and rights on under the, I am always including them, and their estates vested in the state with effect from the date of vesting. This is settled. So vesting of the estate under the state is one thing. And then other thing is what quantum of land can be allowed to the intermediaries to retain by them. So vests everything except the rights of non-agricultural land. I must make a rider to this. Rights of the state, everything stood vest. Then and then, this is vesting is automatic, no problem in it. As soon as notification is published, entire estate belonging to the intermediary or riots or under riot vested to the state. After such vesting, question of retention under section 6 comes in. So everything should be, then what quantum of land should be allowed to be retained by the intermediary or riots?
Only that much as opined by the state to be required for that purpose. Nothing else. Everything else in the factory and will go to the state.
No, certainly not, bro. That cannot be the meaning of this. They must make a limit that
there is not any limit. That is what he is saying.
No,
and we find some substance there.
Even if so, then it also
C has a limit, D has a limit.
Yes, yes.
But
yes.
E says only this. G only says subject to provisions of subsection 3.
Yes.
Land comprising mills. You are entitled to retain mills and factories subject to 3. And 3 says only that much which is opined by the state to be required by you.
Yes.
So therefore, the combined effect is that everything is, if it's a factory or mill, it should by default vest in the state. You are entitled to retain only that much which is opined by the state to be required for mill and factory.
But my submission would be otherwise. Because of this reason, if government did not pass any order, so the entire land should be allowed to be retained to the intermediary. If the government wants to resume the land, then they must pass an order. Then I am in possession of the land. Then question of resumption comes in. Automatic vesting, I have sold, submitted your lordships under section 4 automatically vesting. Then question of retention under section 6. So that is being held by the intermediary or or the mill owners. Then if the government want to take the land, automatic vesting will not allow them to take away the land. There must be an order under section 6(3) to go to the land. It is not like that they are not holding the land. Suppose I have told your lordships, my lord, that the 6(1) proceeded with the 14 various classes of lands which are in the possession of the intermediary shall be allowed to retain. That is to be read, and the section 6, so section 6 heading says that right of intermediary to retain certain lands. So certain lands. So if the government did not pass any order, then the entire land should be allowed to be retained by the intermediary, so long as no order is passed under section 6(3). That is my interpretation. So, my lord, even if no order is passed, government, my lord, again, my lord, don't, my lord, I am not trying to make any confusion. Vests everything automatically in the government. Then taking of possession under section 10, etc. is there. If the land stood vested in the, suppose in extreme case, a person hold land beyond 25 acres of agricultural land, then what happens? Then the excess land belongs to them. Excess land will vest in the state. That vesting is separate vesting, irrespective of section 4. That vesting is the right, title, and interest of the excess land vested to the state, which the government can take possession under section 10. Your lordships have a took the kindly section scope of section 10.
10 comes later, after the vesting.
Later. So
We are on the vesting. We are
vesting
stuck
is,
at
my
the
lord,
vesting level.
to my humble understanding, my lord, vesting is two. Automatically vest everything. Rights of intermediary and
Factories and mills.
everything.
Now your right of retention
No,
comes only
my
after
lord,
6.
my lord, I am.
No, by default everything vests.
By default, everything
Right
vests.
of retention without section 6, everything would vest.
Yes.
If there was no section 6 in the statute.
Yes.
Section 6 is the power of retention.
Yes.
Now we have to read section 6. That is the only provision which permits you to retain.
Yes.
Now regarding factories and mills, there is a specific provision which says 6(1)(g) says you are entitled to retain factories and mills subject to 3. So look at 3.
Yes.
We look at 3. 3 says only that much which has been declared by the state or opined by the state to be required for that purpose. So by necessary implication, isn't it that if the state does not opine that any portion is required for your land?
So there must be an order. Kindly similar.
There is no order.
If there is
Then
no order, automatically allowed.
Automatically, what happens is state does not opine that any portion is needed. It's the other way around.
Yes.
It is a positive order is required that this much is required for the purpose of the factory mill.
Then, my lord, we have to go to the other decisions of this, that Ratnagiri Express, etc., etc. There in these provisions have been made clear, because all those in the cases of land held by the intermediary in excess of the ceiling limit, much quantum of land, then an order is passed, you are allowed to retain this quantum of land, excess quantum vested to the state. Then again, my lord, in Ratnagiri case, the government wanted to resume the land on the ground that you have not used the land allowed to be retained for the purpose of mill and factory. Then order of resumption was passed. But all those things are there. So, my lord, it's automatically mean if no order is passed under section 6(3), the intermediary, I am intermediary holding mill and factory shall be allowed to retain. An order is passed, required to be passed by the government to go into the lands of the landowner or the intermediary, which were in the category of mill, factory, etc.
The other point taken by him is that there has to be a tenancy in the first place to come under non-agricultural tenancy. If there has to be a tenancy, there is no proof from your deed or any document that you were a tenant at all, or your predecessor was a tenant.
My lord, your lordship, if the RS records of right clearly shows superior landlords' names are there.
Let us come to that.
Yes, kindly come to RS records of right. They are page 211.
11, yes.
দখলকার সংক্ষিপ্ত বিবরণ, immediate they are the landowner.
No, they may be the
superior. So it shall be deemed that they are the tenant of them.
Why should it be deemed without any proof of tenancy?
My lord,
you may be a licensee, you may be a trespasser.
My lord, the recording is there.
Recording of the owner's name is on the basis of their ownership.
Ownership. And under them they are.
Now this under them. Dakholkar just being under them does not.
So,
just being under them does not make you automatically a tenant. You have to be a non-agricultural tenant. It being under someone does not necessarily mean that you are a tenant unless you prove tenancy. You may be a trespasser, you may be a licensee.
Kindly see that entire records of right, then পরস্পরের অংশ, then rents are fixed. Rents are fixed. Now, today we are not in a position to say whether we have paid that rent or not. So,
you have not paid is different.
Yeah, my lord, the superior landlord is there. We are under them. then their shares are there.
In your
Then
purchase deed, it says the entire property your predecessor purchased. Entire property became the owner.
we have said whatever right there, the
You have narrated that your predecessor in interest was also the partnership firm, was the owner, and that was an asset of the partnership firm.
yes.
So how
But
can an owner be a tenant?
no, my lord, the owner means, my lord, here they what they want.
tenant.
So they are right as a non-agricultural tenant, and transfer is permissible under section 23, with subject to certain conditions. Non-agricultural tenancy right can be transferred under section 23
It's not a tenant anywhere. It's not stated anywhere you are a tenant.
No, what
Tenant has a meaning.
Yes, I understand.
Non-agricultural, not non-agricultural occupant.
Yes.
Or not non-agricultural possessor or whatever. Non-agricultural tenant. And Mr. Bhattacharya has placed many the sections also, the definitions in all those.
Yes.
To argue that tenancy is a precondition.
46, 47.
46, 47 also.
Yes.
Section 2(5).
Yes.
Very clear, under another person and rent.
Yes.
Then section 5(b). Under agreement with landlord.
Yes, my lord, the
46,
so far as my understanding
that is
is
your
whatever.
agreement with your landlord.
Yes, my understanding is this: the RS records of right reflects that superior landlord is
If you're
there.
relying on the RS records, you were only a dakhulkar under some superior persons. Then
No, we are continuing. They are continuing from those persons, since the under the
Yes,
Bengal
if you
Tenancy Act.
the RS records, you submitted, Mr. Bera, 5 minutes back, that then you are under those owners who have been recorded.
In the CS records of right, same thing has been recorded.
If you rely on this, we
No.
are not saying.
I am not the
You are
same
not
thing.
listening the question, you are answering.
Sorry.
You know the law much better than us.
No.
But you don't know our question much better than us.
No, sir, certainly not.
Because we don't know the law, we are asking you.
No.
You are an authority on the subject.
No.
This is not sarcasm.
Don't say
have
this.
the authority to have sarcasm on you because you know land law. I mean, like the back of your. But Mr. Bera, don't get overawed by that.
No.
Praise, because now it's coming. Now, if you say that if you rely on this record of right and you submitted that yes, you have been recorded to be under the owners as dakhulkar. So then isn't that contradictory with your deed itself, where you say your predecessor purchased, became the owner of the property, and you have purchased the ownership rights from it, and it became an asset of the partnership firm. How, unless you are the owner, how can it become an asset? So isn't that contradictory on this to this? So which one do you rely on, your deed or this? You have to rely on the deed because your title flows from that. Deed says you are the owner.
Yeah.
Here, then you should have purchased from these zamindars who have been recorded as the owner.
So far as that part is concerned, I have to look into that mirror.
Look into what? Everything here you have placed.
You have placed.
Deed you have placed, this you
Yes,
have placed.
mirror, the same thing. The not only the RS mirror, the title of the predecessor and interest of the predecessor flows from the CS records of right. Therein also same thing is there. Mirror,
It's precisely what you are saying. Same thing is there. Dakhulkar under some people.
Yes. No.
Neither
in the
tenancy is recorded anywhere. No proof of tenancy.
No. How this records CS also same that the Uparishatter land superior interest is there. Their shares are there and rents are there.
Superior interest is not sufficient to come under the definition of this non-agricultural tenancy, because these sections categorically state that there has to be payment of rent and agreement with your landlord. These are the languages used in the sections which you just now said.
Yes.
Section 5(b), section 2 with
Yes,
bracket
yes.
5.
Yes.
Not only under another persons, but you have to pay rent.
Yes.
There has to be an agreement. Your person has to be under agreement with your landlord. Where are those agreements with landlord, payment of rent by you, your predecessor, anybody?
No, that agreement is not there.
Not there. It's not there. That is what we are saying.
Yeah, that is not there.
Sections 46, 47.
Yes, yes.
So then it don't come under the definition of non-agricultural tenancy at all.
My lord, my answer is I am trying to give answer, my lord. What has been recorded in the under the Bengal tenancy, my lord, superior landlord's name is there, their share is there, rent is there. Under them, their rights have been given by my predecessor in interest of the petitioner in the column number such and such. Then, my lord, ultimately, his status has been recorded as Dakhalkar. 1, 2, 3, superior landlord, share, rent fix. Then under him, Dakhalkar, and mirror status is Dakhalkar. Entire where their shares are different, that has been recorded in this. I say, my respectful submission is this is sufficient to prove.
Glossary is also there. Dakhalkar, the meaning has been expounded
Yes,
here.
yes.
Dakhalkar does not include a tenant.
No, doesn't include tenant.
Dakhalkar, the definition.
Yes, glossary. Is not tenant within the meaning of BT Act.
Occupant, also possessor of an interest.
Yes.
Never used in the case of a tenant according to section 4 of the BT Act.
So, mirror.
Dakhalkar is by itself not tenancy.
Not tenant.
So then where is your tenancy?
No, not tenant under section 4. Not otherwise.
When did you become a tenant then?
Because of this continuance of this.
You say from the CS records the name is reflected like this.
Yes, like this. Remember, so far as this survey or the glossary, they are in clear.
CS record was on the basis of which act?
Bengal Tenancy Act.
Then if CS records say Dakhalkar,
yes,
and the Dakhalkar definition says that it's not a tenancy under the Bengal Tenancy Act.
Yes.
Then what is the implication?
They are holding the lands under the superior landlords. Tenants means various. What where I am joining issue here. Tenants of not class specified in section 4.
Very good.
Tenure holder, etc. So that kind of tenant he is not, but he is holding the land under the landlord.
So
on some
Dakhalkar is not per se, it's not tenancy. That's what
not
you're saying.
tenancy, not
Maybe
tenancy.
not tenancy,
Not tenancy.
but also not tenancy.
May not be tenancy under the Bengal Tenancy Act, but other classes that non-agriculture under the non-agriculture, if he is holding the land under
no document to show that you are
no
a
document is there, but by virtue of definition, classes
it
of
says you are the owner, your predecessor was the owner, assets of the partnership firm. Where is the tenancy? We don't find it. If you are the owner, then you cannot be the tenant simultaneously. Your title deed, you derive as far as you are concerned, Mr. Berai, your client is entirely dependent. Your source of title is the deed, which says ownership is being transferred to you. How do you claim tenancy? You are stopped on that ground, stopped on that ground also.
No,
by your own deed.
No, my lord,
Deed
my right flows from the right recorded in the CS records of right and
no. Your right comes from that deed first.
No, my rights
then
come
we go
from
back.
the deed. No, that's
then
why
we
I'm
go
saying.
back. Your
But
deed
the-
itself says you are an owner.
ওটাতে কি আছে দলিলে কি আছে দেখাও তো দলিলটা বের করো
আমি বুঝে আছি কিছু যদি দেখা যায় হ্যাঁ
যে পাতাটা দেখিয়েছে দেখা টাইম টেলিং দেখি 120, 121 দেখে পেজ 120 121
তো জিনিসটা বলেন
Sir, if you see page 133 of the writ petition once.
My lord,
Page 133 of the writ petition once.
of the writ petition.
Yes. Volume 1.
एक writ petition to 130. What is 133?
Please see the last clause 4.
Specific paragraph, refer.
Paragraph 4, last 133, absolutely.
Yes, Mr.
Bottom. The vendors and or every person or persons having or lawfully claiming any estate right, title or interest in to or upon the said premises hereby sold, conveyed and transferred unto the purchaser or any part thereof to or under or in trust on.
Yes, my lord. Whatever right they had, estate right, interest in or into the premises here by number that partnership, my lord, the entire deed, my lord, is required to be read, my lord, in that case, my lord, to submit frankly before your lordship the entire deed, what has been stated, one or two piecemeal statement in the context, that is, my lord, possibly with regard to the
Kindly also see page 121.
Clause 4.
Clause 4.
All messages, lands, buildings, heritagements, and premises, together with factory shed, godown, warehouse, everything, all other erections on the property, with fixtures and fitting, etc., were commonly known as valley bone means, and one transformer were acquired or purchased by the said firm and were all along dealt with as an undertaking on assets of the said firm. Now, it's the asset of the firm, they purchased, acquired or purchased.
yes.
So that your vendors claim title to that purchase. They're the
Yes.
owners of that property.
Yes.
And then read with that page 133. Not only clause 4, the previous clauses also. Clause 3 is also there.
Other purchase deeds are there, my lord.
So it's a purchase, outright purchase, ownership is transferred.
Yes.
Clause 3 at page 133 also says the said property and premises hereby sold, conveyed and transferred unto the purchaser, free from all encumbrances, claims and demands, whatsoever created, occasioned or. So ownership rights are transferred to you lock, stock, barrel without any encumbrances. Lease would be an encumbrance. So there is nothing. You ownership, they got ownership, they transfer ownership to you. So what is the concept of non-agricultural tenancy here? You are the proprietor, owner, whatever you say. It takes you within the fold of this intermediary. Yes, Mr. Bera, both sides put in your short written notes of arguments. How soon can you do that? Just brief, 3-4 pages. Whatever you have argued, those points. How soon can you do that? Thursday. Whether they can.
থার্সডের মধ্যে পারবে থার্সডের মধ্যে পারবে
বুধবার ছুটি আছে
মিলো থার্সডে যে
You have Wednesday. You have a holiday on Wednesday. That's why he's saying Thursday.
no we have not Wednesday, possibly it will be 16th Thursday.
No. 26 Wednesday.
ছুটি আছে।
Wednesday is
is
a
holiday.
holiday.
Wednesday is declared.
We have a day off.
Kindly have it Monday. Better.
অন্য কিছু ব্যাপারে ভুলে যায়, ছুটির ব্যাপারে ভুল করে।
Very good. Monday.
Monday.
Hearing is concluded. First of learned counsel for the parties are requested to file their respective brief written notes of arguments on on August 31, 2026, when the matter shall next be listed for such purpose under the hearing to be mentioned. Thank you.
কাছাকাছি রাখুন, কোথাও এলাকা নিচে তো চালা আমার চাকরি না, এটা আপনার
এটা আমার ওটা রাখুন আপনি।
স্টেপ করে
ওইটা কি আপনার? হ্যাঁ, ওটা আমার।
আপনার চালা
ঠিক আছে আমার।
আপনারটা নিচে আছে।
ঠিক আছে।
এদিকে একটা স্টেপ করে দেবেন। আর এইটা কিন্তু কপিগুলো মনে আছে তো?
ভুলে গেছিলেন? এবার বলবেন।
ওই দুজনকে একটা করে কপি করে
ওটা আমার বই না। ও আমার, হ্যাঁ আমার বোধহয় কিনেছি নতুন। ও সরি মুখটা বানিয়ে ফেলুন ছোট করে। ও সব বোনাস
আমার দ্বারা হবে না।
আমার কাছে
ল্যান্ড ম্যাটার আমার মাথায় ঢুকবে না।
আপনি আর্গুমেন্ট করে
তো লোড করে করেছি।
This is essentially seeking clarification and modification of the order passed by the learned tribunal. So the backdrop of the case, the property was recorded in the Hari's record of right as Bagan and VT minor. Well, subsequently in the LR record of rights, the same has been changed. The petitioner before your lordship used to stay in Kolkata. He
Use the microphone, just take it closer to you. Yes.
My lord, in LR record of right, the classification of the plots changed automatically without any application by the petitioner before your lordship. As it came into his notice, he made an application before the revenue authority for change of classification. Well, that was rejected. In 2009, my lord, I made an application that was rejected. My lord, I carried out an appeal, my lord. Appeal was also rejected. Now, then I approached before the tribunal. Now, learned tribunal has held the issue in my favor. Surprisingly, my lord, if your lordship turns to last page of the order, without passing any mandatory order, has directed to make an application before the tribunal for inner page 8, my lord.
Let us see the previous page. It has been, the classification has been changed to Khalarmat.
Khalarmat.
No, it has not been held in your favor. Everything else is not in your favor.
Concluding paragraph, it has
come from page 6 onwards.
6 onwards.
The tribunal does not hold in your favor.
Yes, my lord.
The tribunal says it's apparently Khalarmat and all.
My lord, if your lordship turns to page 7, on mere presumption and assumption, the property was being used by the family members of the Rayat concerned, so it was recorded as Khalarmat. And eventually, my lord, has...
But this is not in your favor, against you.
No, the concluding paragraph says, my lord, if your lordship turns to page 8, giving a liberty to make an application before the DL and LRO. The applicants are given liberty to file appropriate application under section 4C of the West Bengal Land Reform Acts in prescribed format before the DL and LRO Hooghly within 1
From
month.
page 7 onwards.
Yes, my lord.
Please, sir, please don't disturb the arguments like this. Come from the side then. This is not the way it's done. An argument is going on, you're pushing him and just giving a slip. Please come from page 6.
Page
Let us
6.
read from page 6.
Yes, my lord.
A bare perusal.
Yes, my lord. A bare perusal of both the orders above would reveal that the appellate authority has simply adopted the observation of the revenue officer, and the moot point taken by both of them is the effect of KB operation, as if whatever has been done during KB operation cannot be questioned or challenged. It is also hard to accept the argument put forward by the learned government representative to the effect that after the change of classification during KB state, the same Muja was placed before draft publication under section 51A1 and again after final publication under section 51A2, during when the applicants did not challenge against the classification, and after final publication it reached finality. We have meticulously scrutinized all documents placed before us, but it is worthwhile to mention that the state respondent could not produce any relevant documents relating to plot Badar proceeding by PB 39 taken place during KB stage of LR operation. Upon hearing the submission made by the learned government representative for the state, it is understood that during operation of LR map, the concerned Mauja in terms of technical rules 1952 full Kistarwar pot of plot survey was taken up, and in those process amalgamation and splitting of plots took place by virtue of plot Badar, and the instant case of PB 39 is one of such case of amalgamation and splitting based on the actual status of field position. This is probably in RS the plot was 2, in LR it has been divided into 3. It may be presumed that during period of I am harping on this. It may be presumed that during period of plot serving, the field level functions of LR's setup might have noticed vacant land being used for game sports by the members of the family of the riot. This is mere assumption and presumption with my respectful submission.
Yes, but you said everything else is held in your favor, but everything else is against you also. Assumption is a ground of challenge, definitely.
Yes, my lord. These assumption
Nothing is in your favor. Yeah.
Well, ultimately, liberty has been given to make an application. That is why I have started with.
No, that is based on the previous these remarks.
Yes, my lord.
Assumption is that it is now being used as a calamart, so you can
No, my lord, the assumption is
regularized it.
at the time of KB operation, probably.
Please read on. Which
Sorry,
assumption?
These assumption gets strengthened when we find that against the classification of calamart, no ismentary right has been noted in the remarks column of ROR. From the KB ROR up to finally published ROR of the subject land, no ismentary right has been reflected, wherefrom it can be concluded without any ambiguity that the subject land being classified as calamart is meant exclusively for the family members of the riots. That is present applicants. Now, in terms of section 4C of the West Bengal Land Reforms Act 1955, if the applicant being the riot's lawful owner intend to change the classification from calamart to Vastu or Bagan, nobody can raise any objection against it. This was the observation. And ultimately, a liberty has been given to the applicant to make an application before the DL and LRO for change of nature. My humble submission is that at any point of time, which is required under section 4C of the Act, I didn't make any application for change of nature of character of the land. So instead of passing an order granting liberty,
can't the records of rights be revised?
I didn't make an application. No mandatory order has been
under section 50. Can't it be revised? Let us see. Land Reforms Act. I'm sorry. '51 says the state government may, in any case, if it so thinks fit, make an order directing that records of right in respect of any district or part of a district be revised or prepared by a revenue officer in accordance with the provisions of this chapter.
That has
to be a general.
That is with regard to the.
His will be 51B.
No, that is with regard to the change of. That is not the change of classification.
51B, Mr. Banerjee is right. Please come to 51B. Or on its own motion. Yes. 51B is the right provision. So that can be done by the state government. State has the power.
No, my lord, what I am on, ultimately the tribunal has given me liberty to make an application for change of nature of the property. This is 5150B, the title, if it flows from one person to one, then section 51, subject to kind correction, my lord.
Condition correction.
My lord, this is here, my lord, at any point of time, the applicant did not make any application to change the nature and character of the. And mere assumption and presumption, my lord, it is being used by the.
On the basis of the current user, irrespective of any conversion application being, suppose it's illegally made, what will be the effect? Regarding, suppose it was being used as a bagan or whatever. Now it's being used as a khalar mart. This is not a change of character as such. Yes, the nature of user is being changed, but the character of the land is not being changed. So it's not that a water body is being converted to a something else land, or that it is being converted to a bastu, or a construction is coming up, whereas it was originally a forest area or something like that. So bagan and khalarmat is very vague. I mean, in the sense that a bagan can also be a khalarmat. So on the basis of current user, can't the state under section 51B, as rightly pointed out, have a revision of any entry of the record of right?
What that?
Noting down that there is a change in the user.
My lord, that is why, my lord, I have rightly, my lord, at the outset, my lord, I have said the paragraph 7, mere assumption, presumption. Why, my lord, the property is located at Hooghly. If your lordship kindly consider the.
Even this assumption, presumption was not necessary. Tribunal could merely have affirmed the order of the appellate authority and the first authority by saying that no, state has the power to do it unilaterally.
No, my lord, my contention, under any circumstance or any point of time, we didn't make any application.
Without any application, 51B does not require an application.
No, 51, under section 4C for change.
Very well, we'll set aside that part of the order, we'll modify and we'll say no liberty is given to you to make an application for conversion. We can do that right now. We'll set aside that part of the order. If you're so happy, we will be happy with that.
No.
Then we are setting aside that liberty given to you to have a change of conversion. That will set aside. But the rest of the order remains.
Not kindly appreciate.
You are bypassing our question. Our specific question is, can't the state unilaterally suo motu without any notice to you or without any application by you change an entry under section 51B? Read 51B.
My lord, may I?
Please read out.
My lord, what may I take?
You could have argued that yes, a notice ought to have been given to you, but you have to base that on the section. Let us see the section.
My lord,
Lordship,
any revenue officer.
Lordship, may I take 1 minute time? What is he
No,
saying?
let him please. Yes.
Any revenue officer specially empowered by the state government in this.
Yes. Giving opportunity of being heard. So no hearing was given to you. Yes, Mr. Banerjee, you have that 1 minute.
What? He is saying that end of the day, good, bad, indifferent. Your order
You are
has
for
been.
the state.
I'm for the state.
Yes.
He is saying good, bad, indifferent. End of the day, both the trial court and the first appellate court order is set aside. So if it is set aside, then I should have a mandamus to get it.
Those are set aside?
Yes,
my lord.
That's what your lordship.
That is why
Your lordship, see, last line of the.
Where is your grievance? You have been given liberty, don't exhaust that.
Lordship, a minute. Lordship, there is a nice question. What he says is, if it is set aside, then there has to be a mandamus. That's what order-like nature of mandamus. Now, Lordship, when
your prayer was allowed by setting aside.
Yes,
my lord.
yes.
Well,
So,
that is why, my lord, I have said I
Lordship,
see
when it came
certain
with my
modification of the order.
Only that conversion part.
Only that conversion part, directing mandatory order to the authority, because one thing more, my lord.
But you have not prayed anything before.
You are given liberty to file appropriate application.
Yes, Lord.
In the prayer.
Is the
Yes,
liberty.
Lord.
Well, that I have seen, my lord. That is not correct.
Yes,
Drafted,
Lord.
my lord.
Yes.
Well,
Not to issue mandamus, not to issue circular.
Yes.
I mean,
that's why I didn't open the prayer portion, my lord. That is, I am before you.
prayer portion we can grant you liberty to modify, but what about this? What is the challenge? You can't still understand.
My lord, the direction has been
in your
given
favor,
to
everything is
consider.
quashed.
Yes, well, no, I am not. That is why I have said modification. Well, this is the direction since 2000.
Which part? Modification of which part? Read out.
Yes. Application under section 4C such a prescribed format before the dealer who
Applicants are given
month.
liberty
Yes.
to file appropriate application in prescribed format
Yes.
in 1 month.
Certificate copy this order in
Even
this
the
manner,
filing-
will dispose of the same within
You can
60
file
days.
it as simple as that. You're given a liberty, no direction on you.
Lord, kindly give a mandatory direction. That is why, my lord, I have.
No,
Why mandatory
what
direction?
is
How
saying
can
mandatory direction, not on
Because
him
that
to
was
file.
the-
He said mandatory direction, actually.
True,
Mandatory direction upon the revenue officer to correct it. That is what he is wanting.
My lord, what I am on, my lord, let there be direction upon the district land and land reforms officer. I'll be making an application as per the liberty given by the tribunal that is to be disposed of, my lord, within a certain period time mandatorily, my lord. First thing, and one thing more, my lord, for this, my lord, at no fault of mine.
So
I
that
have
that
to-
cannot be an application under 4C.
Yes, my lord.
That
Also,
cannot be an application under 4C.
4C on
4C is for conversion.
conversion. Because if it is under section 4C, then I have to pay a huge amount for conversion also.
No, that we understand.
That is why.
Yes.
Conversion is টাকা দিতে হবে।
বাগান থেকে খেলাই হবে না, পুকুর
So
থেকে
what will you be applying for?
A mandatory direction directing the authority to correct the
To correct the records.
records, my lord.
Yes, now Mr. Banerjee.
No, Lordship, I was exactly found.
You agree to that?
No. I leave it to your Lordship, but what I found in the book is, if we see section 6 and section 7 of the LRTT Act, that says they will exercise all power except the power of 226 and 227. That means that mandatory nature is not there with them. If your Lordship, just I have taken a look.
Sir Banerjee, if your argument is accepted, then there would be no scope of challenge to any inaction.
No, there is. Why? Because the all bad
There
orders.
is inaction unless there is a direction. Where is the question of an
No,
inaction
no,
being?
not that direction. Direction has to be there. What I am saying is correction of record direction. It has to be done by the revenue officer. He will send him back to the revenue officer with all direction.
That's what he's asking for.
That probably he got. Now he is asking to skip that portion of Revenue Officer Act.
Not get. Only the orders were quashed without
Yes.
passing any further direction.
Yes. Then he said, make
The
an
revenue
application
officer
and get it corrected.
Wanted correction. So he says that should not, the orders.
He says that
clearly-
I need not to make any application.
No,
No,
no, no.
he does not
Strength
say.
of this order, I will correct it.
No, 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 no. That is not I have said. my lord.
তাহলে কি চাইছো? বাকি তো তুমি সব পেয়েছো। দেখো।
What I am
Take an
on, my lord?
application for correction of the records of it.
My lord.
You made that in the first place.
If it is considered under section 4C, my lord, then
That you under 4C will, you want a modification of this? And in the first place, you had an application for correction of the record of right. That was rejected by the revenue officer.
yes, my lord.
Revenue officer rejected on what ground?
Or I didn't raise any objection at the appropriate stage because the
see that.
stages were over.
We have to return it at that stage. So let us see that order.
Yes, my lord. My lord, probably
51 BB হবে 4C এ যায়।
What is that?
not, it appears order at page 39. No, page 38 starts from page 38. Relevant portion has page 39. Order number 3 dated 13 September 2012.
Yes, Mr. Banerjee, on merits, what do you have to say? Why this order cannot stand? He does not have the power to correct.
He has a power to correct.
Without any conversion proceeding. He is wanting the reverse. It should be restored to its original entry. And he will make a conversion application. Why?
When the record is found, Lordship kindly see, the court even could not, this subject, if your Lordship says, court found there is a certain proceedings done. After that proceedings, record prepared. After preparation of the record, he says that kindly correct this record. This is not correctly done.
That application should be remanded at that stage. He had
Yes.
already made an application which was rejected on a wrong ground of.
Yes.
So we just remanded to the revenue
That's
officer to decide that
Yes,
application on
yes,
merit.
yes, yes.
That is what we'll be doing, obviously. What else?
That's
The grievance of the petitioner is limited. First of next para. The entry against the subject plot initially appeared in the RS records as within double inverted Bagan double inverted close. Full stop. However, comma, subsequently the same was altered in the LR records of rights to TO2 Khalar Mart within double inverted. Full stop. When the petitioner approached the concerned revenue officer within bracket B and LRO, petitioner sorry, BLLRO, comma, by an order dated September 13, 2012,
12, my lord. Initial
2012,
application
comma,
2009.
the BLLRO opined, rejected such application on the ground that it is beyond the jurisdiction of the BL and LRO to correct the record of right as per law and rules without any conversion proceeding. Full stop. Next para, an appeal was preferred against the same. Full stop. However, comma, the appellate authority affirmed the said order, comma, giving rise to a challenge before the West Bengal Land Reforms and Tenancy Tribunal. Full stop. The learned tribunal, comma, by the impugned order, comma, disposed of such application by quashing the orders of the revenue officer as well as the appellate authority, semicolon. However, comma, a liberty was given to the petitioners to file appropriate application under section 4 capital C of the West Bengal Land Reforms Act 1955 in prescribed format before the DL and LRO, comma, Hooghly within 1 month from the date of obtaining certified copy of the order, and in the event of filing such application, comma, directing the DL and LRO Hooghly to dispose of the same within 60 days thereafter. For sub next para, learned counsel for the petitioner submits that in view of the orders of the appellate authority as well as the revenue officer being set aside, comma, the learned tribunal ought to have granted liberty to the petitioners to apply not under section 4 capital C of the 1955 Act, but for correction of the records of rights, comma, upon which the concerned revenue officer ought to have been directed to correct the records of right accordingly. Full stop. Next para, learned counsel appearing for the state argues that what is your argument basically? You almost supported the.
No, that's what I said, that it should go back to the stage where it
So
was.
should we record that? What should we should record something that you're vehemently opposing or something? Choose your adjective, we'll put it. না ওটা দেওয়া দরকার নেই, learned counsel for the state না বলে heard learned counsel for the petitioner as well as the state. For some next para, it transpires that the revenue officer within bracket BL and LRO rejected the application for correction of records of right made by the petitioners on an erroneous ground. Full stop. The grievance of the petitioners was not that the petitioners seek to convert the nature of the land, but that the recording of the nature of the land in the LR records of rights was erroneously made, comma, which tantamounts to a rectification without giving any opportunity of hearing or notice to the persons concerned, interested, comma, including the petitioners. It is further submitted that there was no basis for making such alteration in the records of rights, in the LR records of rights. Next para, upon hearing learned counsel, comma, we find that the relevant provision, comma, as rightly pointed out by learned counsel for the state, is section 51 capital B of the 1955 Act, under which any revenue officer specially empowered by the state government in this behalf may, comma, either on an application or on its own motion or his own motion, comma, at any stage of revision or preparation of the records of rights under the concerned chapter, but before final publication of any such records of rights, comma, revise or correct any entry in such records of rights, after giving the persons interested an opportunity of being heard and after recording the reasons therefore. Italic says full stop. Next para, in the present case, comma, we do not find any such exercise having taken place. Full stop. There is nothing on record to indicate that any opportunity of hearing was given to the petitioners, comma, in whose name the concerned plot is recorded, comma, nor do we find any material being placed before any of the authorities recording the reasons for such alteration. Full stop. Thus, comma, moreover, comma, the circumstances of the present case are not covered under section 4 capital C of the 1955 Act, which contemplates a riot holding any land to apply to the collector for change of area or of character of such land, or for conversion of the same for any purpose other than the purpose for which it was settled. Full stop. In the present case, comma, since the petitioners do not want any such conversion, but just the reverse, comma, the invocation of section 4 capital C and the liberty granted thereunder by the tribunal was misconceived. Full stop. Next para, the appropriate direction would be for the tribunal to remand the matter to the BL and LRO for the purpose of a fresh consideration of the petitioner's application for correction of the entries in the records of rights. Full stop. Next para. Accordingly, WPLRT 142 of 2026 is allowed, comma, thereby setting aside the impugned order of the tribunal dated September 4, 2025, passed by the second bench of the West Bengal Land Reforms and Tenancy Tribunal in OA 2840 of 2016 within bracket LRTT, and directing the BL and LRO which area? Must be a
BLR
party.
Singur.
Huh?
Singur, BLR Singur.
Right. Directly the respondent number 4 herein, that is the Block Land and Land Reforms Officer, comma, Singur, to adjudicate the petitioner's application for correction of the records of right afresh on its merits upon giving adequate opportunity of hearing to all interested persons, comma, including the petitioners and the state, comma, and to pass a reasoned order thereon, and to dispose of the same by passing a reasoned order as expeditiously as possible, comma, preferably within 6 weeks from the date of communication of this order to the respondent number 4. Full stop. Next para, it is made clear. Now, consequentially, comma, the orders passed by the BL and LRO, passed by the respondent number 4, dated September 13, 2012, in miscellaneous case number 91 of 2012, as well as the order of the appellate authority affirming the same, are set aside. Full stop. No orders to cause urgency required. Thank you. Leave is granted to the learned advocate on record for the petitioners to rectify the prayer portion of the writ petition. Affidavit of self felt to be kept on record. এই দুটো একদম উপরে যাবে।
Deeply obliged. মাত্র।
Well, kindly, I am paying only not today.
No. Please move the matter.
Hello, I filed affidavit on the last occasion.
Yes, it's on.
Well, this is with regard to inaction, non-action. I approach the tribunal. They kindly come to the order passed by the tribunal. Learned advocate appearing for the applicant submits the instant original application being such and such has been filed against the inaction on the part of the BLR of Punjab district Purulia in the matter of disposal of the applicant representation being such and such. Now they come to the
Which
learned
order? 1st of September order?
lordship. Well, the learned government representative raises vehement objection on the following grounds that the representation has been submitted in the name of multiple addresses, and that the forest department has not been implicated as a party in the representation, particularly when the subject land belongs to the forest department, and that the secretary forest department has not been implicated as a party to the instant original application. Now, further, that no direction may be issued upon BLR concern for disposal of such a defective representation. But my submission is this: I'll make a fresh representation before the BLR and will dispose it of within a certain period.
You want to make the representation before the BL and LR only?
Yes.
Only BL LR?
Yes.
But
it was before the BLR.
It has been held to be a defective representation. Nothing prevents.
Then I make him a party also, the forest department.
What do you want to do? Make the forest department and the but the representation was not given to the appropriate.
I gave it to the BLR.
Presentation is at page 125.
Secretary Forest Department has not been implicated in all these things at there.
Yes, sir.
But in the present application, I've made him a party.
Look, give a fresh representation that will be decided.
Lordship, that is my prayer also.
You want to give a fresh representation to these authorities who were omitted in the first time.
Lordship.
The prayer of the writ petitioner is innocuous. Full stop. A representation was made by the writ petitioners to the district land and land reforms officer, Purulia, subdivisional land and land reforms officer, Manbazar, and the block land and land reforms officer, Puncha, PUNCHA, with regard to But where is the question of forest officer and all them?
Well, these land were vested to the state, and right now it has been recorded in the name of the forest department.
With regard to, you sought a correction of the records of rights.
Lordship.
Yes. Seeking correction of the records of rights. Full stop. Next para. Learned counsel for the petitioner submits that the property has now been recorded erroneously in the name of the forest department. Full stop. Next para. The learned tribunal, while disposing of the application filed by the writ petitioners alleging inaction in deciding the representation, held that the representation was defective and accordingly dismissed the original application. Full stop. The premise of so holding was inter alia that the appropriate authorities, including the secretary, forest department, had not been implicated as respondent, nor was the representation given to the appropriate officers of the forest department. Full stop. Next para. Learned counsel appearing for the state submits that the representation dated March 25, 2019, which is the genesis of the present litigation, was defective, as rightly observed by the learned tribunal. Full stop. We find substance in the contention of the state. Full stop. Accordingly, WPLR 145 of 2025 is disposed of without interfering with the impugned order dated September 1, 2025, passed by the 4th bench, West Bengal Land Reforms and Tenancy Tribunal in OA 1819 of 2020, LRTT, semicolon. However, granting leave to the petitioners to send a fresh representation impleading the appropriate authorities, including the concerned authorities of the forest department. So if such a representation is given, the said authorities shall decide the same as expeditiously as possible in accordance with law, by a reasoned order, upon giving opportunity of hearing to the writ petitioners, the state as well as the appropriate authorities and any other person which may be interested. First up, it is expected that such exercise shall be concluded within an outer limit of 8 weeks from the date of giving such representations. No orders to cause service. 8 weeks would be sufficient.
Lordship.
Yes.
1 and 5B and
Yes. Yes, Mr. Shaw. Mukherjee, take your seat. Mr. Bhattacharya, take your seat. Mr. Shaw will have.
Yes, Lord. Before going to records, my lord, just bear me. What is my case? My learned and client, my lord, predecessor interest, my lord, accrued his right from the inception of the BT Act. They got the ijara in the year of 1903.
1900?
1903. That is for a limited term, for a period of some time, my lord, on the basis of the rent. Thereafter, my lord, their name was reflected, the rent was paid to the superior landlord. I am the tenant in respect of this property. I have paid rent, my predecessor paid rent till coming into the force of the Estate Acquisition Act. Now, my lord, their name was recorded in the CS record of right as a my lord, the intermediary, Madhyasattadhikari intermediary. Immediately thereafter, the Estate Acquisition Act come. Now, under the Estate Acquisition Act, till coming into the force of the Estate Acquisition Act, rent was paid. Our name has been recorded in the CS record of right. And immediately after coming into the force of the Estate Acquisition Act, my lord, if my lord, during the period of CS record, I have paid rent till 1361 BS. Your secondly, my lord, I have prepared a list of dates. It will be better. It is just now, immediately after coming into the force of the Estate Acquisition Act, my lord, that I have paid rent till, my lord, started from 3062 BS, because my lord, first my lord, the Boisak 3062, my lord, the Estate Acquisition Act come into place. That is the date of vesting. And thereafter, my lord, my name has been recorded in the RS record of right. Thereafter, my lord, in the LR record of right, my name has been recorded as a Rayod in respect of this property. And till today, my lord, I am paying the rent in respect of this property in question.
This did not vest under the Estate Acquisition Act.
Yes, I am coming, my lord. It is vested under the, I am coming. Now, my lord, the private respondent, they make a, my lord, the objection by saying that in respect of 3 plots, our name has been recorded erroneously in the RS record as well as the LR record. The dispute crops up from here. Now, they made a representation 1992. A writ petition was moved before this Honorable Court. Justice N.K. Mitra, lordship then was, my lord, passed an order directing the respondent to consider and dispose of this matter. Now, in pursuance of this order, my lord, a proceeding under section 50 of the West Bengal Land Reforms Act was initiated. In that proceeding, 2 or 3 things were discussed in that proceeding. I will I will show you lordship later on. That as on the date of vesting, as the rent was paid till 1361 BS. So after the coming into the force of the Estate Acquisition Act, rent was paid to the state. He became the director and under the state, and he is also the khas possession in respect of this property. Accordingly, there is a big the order. Accordingly, the authority says that RS record of right and LR record of right, which was prepared in favor of my predecessor's interest, it will remain unchanged. Challenging that, a writ petition was moved by my learned friend client, private interest. Now, this Honorable Court, Justice R. Bhattacharya LLC then was, my lord, recorded in its judgment by saying that as if the private respondent moved the writ application challenging the order of vesting. It is not the case. Now the Honorable Court passed an order, setting aside the order passed under Section 50, directed the authority to proceed afresh upon taking into consideration all the records, if necessary inquiry and all these things. On the basis of that, my lord, the proceeding was drawn up. In that, again, my lord, Section 50 proceeding. In that proceeding also, my lord, decision was that our name will remain unchanged. That is the record of right as prepared in the RS and LR. That is correctly done. It will remain unchanged. Now, challenging that.
When did you come in? Your predecessor was still there.
Still there. At that point of time, that is that. But before that, I have forgotten, my lord. In the year of 1911, the superior landlord, my lord, filed a case for eviction under the BT Act, 105 of the BT Act. That suit was dismissed. That suit was for eviction and recovery of possession. That was dismissed. So the possession, my lord, till coming into the force of the, my lord, the BT Act and up to the, my lord, the Land Reforms Act, that is confirmed. And it has also been recorded and rent has also been paid. Earlier it was paid to the landlord. Thereafter, immediately after coming into the force of the estate acquisition, I have paid rent to the state. And thereafter in the LR record of right, I have paying rent and our name has been recorded in the record of right. This is the whole case. Now again, my lord, Section 50 proceeding was there, same result. Now they preferred appeal before the appellate authority under Section 54. The appellate authority, my lord, was of the view, they recorded that I am interrupted in possession in respect of this property. Now the question comes that under Section 89 of the BT Act, which provides, my lord, you will kindly see. Thereafter I will go. But this is the turning point. What the I have got my two books I am giving.
Yeah.
বই আছে BT Act. দুটো আছে?
You have also got two books.
Now, Your Lordship, kindly.
Yes.
Your Lordship, kindly come Section 89 first.
69.
Yes. Yes. No ejectment except in execution of a degree. No tenant shall be ejected from his tenure or holding except in execution of a degree. Yes. Now the appellate authority passed an order holding that yes, we are possessing the land, no eviction, nothing of the sort. In spite of that, passed an order that a proceeding under Section 44(2)(a) to be initiated in respect of us, and in respect of the private respondent, they are claiming that the land belongs to the Devattar property. So proceeding under Section 6(1)(i) is to be introduced. This is under the Estate Acquisition Act. Two proceeding, my lord, parallel, my lord, proceeded with. Two proceeding was parallel proceeded with. In respect of 44(2)(a), it was again, my lord, held. Yes, the RS record of LR record of right, which has been prepared in favor of our client since the date of predecessor interest, that is rightly done. It will also remain unchanged. But with regard to section, without the provision under Section 6(1)(i) of the Estate Acquisition Act for determination whether the land belongs to Devattar or not. But the private respondent failed to produce this, failed to prove that this land belongs to the Devattar. Accordingly, my lord, the proceeding under Section 6(1)(i) was rejected. Challenging that, a writ petition was carried, my lord, before this Honorable Court, and subsequently it, my lord, transferred to the learned tribunal, and it was registered as TA 791 of 2000.
TA?
TA 791 of 2000. My lord, I will show your lordship details, my lord, the judgment. I'm just giving the, my lord, the background of this case and thereafter. Now, this TA was disposed of by, my lord, the remanding back by saying that a 44-2A proceeding is to be initiated and the inquiry is to be made. All the documents will be produced by either of the parties. But a cryptic order was passed. That is why, my lord, again a writ petition under WPLRT was moved before this tribunal. Justice Torun Chatterjee actually then was, my lord, division bench. My lord, quashed it, remanded back. The
No,
tribunal.
No, initially, who had remanded first?
First, my lord, with regard to the, my lord, the
TA 791 was before which authority?
no, TA 791 is the tribunal. My lord, before that, writ petition was moved before the Honorable Court, challenging the order passed in 6 and 619. And immediately, as soon as the tribunal was established, the matter was transferred.
That's
to the
right.
tribunal. Yes. Now, the private respondent, my lord, preferred an appeal under section 44(2)(a) of the West Bengal State Acquisition Act, but it was withdrawn. So, 44 findings of the 44(2)(a) reached its finality.
Yes.
Now, they, my lord, during the currency of the proceeding before the learned tribunal, my lord, they filed a supplementary affidavit, my lord, for invoking, my lord, the order passed in 44(2)(a) after withdrawal. Now, both the, my lord, matter was taken up for consideration. Now, the tribunal ultimately, my lord, passed an order by saying that two things is to be taken into consideration. One, that whether as on the date of vesting, who was in possession, number one. Secondly, whether there was a eviction under section 89 of the BT Act. Two things. Because, my lord, these two rider was given by saying that if the earlier in the year of 1911, eviction was there, eviction suit was there, failed. So,
Mohan
as
Bagan and you won in the same year. Mohan Bagan and you won in the same year. Yes, against East Yorkshire.
1911.
You won against your landlord.
And I have seen in the while going to the Rajbhavan, Rajbhavan also 1911. I have seen it in the emblem. However, my lord, so my lord, the eviction is not there. Now that is why two riders were there. If as on the date of vesting, who is in possession, number one, and secondly, whether the section 89 was, my lord, the complied with or not. These are the two riders. Now the
Section 89 held in your favor, no proceeding.
no proceeding, nothing of the sort. There is a specific finding also there.
Possession. You are not in possession.
Yes, yes. Till that I am in possession.
No, it was held against you, possession.
No, possession is with me. But the crux of the matter is that in the CS record, up to 1338 BS, my lord, it is recorded that I have been treated as a intermediary on the basis of the Meadi Ijara. Because in the year of 1903, I have got the Ijara on the basis of which I have executed a Kabuliyat. On the basis of this Kabuliyat, all the lands I have, my lord, possessing the lands, I am holding this land. And thereafter, till coming into the force of the estate acquisition, before that, I have paid rent to the landlord. And thereafter, I have paid to the rent to the state. And my lord, initially, my lord, the Kabuliyat was for a certain term, 4 years. And thereafter, after payment of rent, up to 3061 BS, that the tenancy, my lord, the lease or tenancy, whatever may be the case, my lord, it was extended just before the coming into the force of the Estate Acquisition Act. That is admitted. Now my lord, I will come, my lord, after the order passed by the learned tribunal. On the basis of the learned tribunal, a proceeding was initiated by the SDLRO concerned. The SDLRO discussed all these things, only said what is against me, what he has said, that admittedly, my lord, no recovery of possession, no eviction, section 89 was not complied with, private respondent could not produce any degree in respect of the under section 89. Only they said that we produce, my lord, the Kobuliyod is there. Thereafter, in the year of 3060 BS, 2 rent receipt which was issued by my immediate landlord, recording that the rent receipt has been issued on the basis of the ijara. They are the superior landlord and we are the tenant in respect of this property, and area rent was paid from 1358 BS to 1361 BS. That is immediately after coming into the force of the Estate Acquisition Act. So continuation is there.
1358 to
1361 BS. Because
you said the 2 receipts were of 1360.
60. Bokeh, my lord, they
Receipts were of 1360.
60, yes.
How could then we receive the receipt be given for up to 1361?
Because they have
In advance.
advance, bokeh, that is the area.
Okay, means arrears, not
Area,
advance.
area, yes, area.
61.
61, up to 61. That is, my lord, the up to before coming into the Estate Acquisition Act.
Very well.
Yes. Now the authority held that I failed to produce, my lord, what they have said. I failed to, with regard to the eviction, all right. But with regard to the, my lord, the up to, after 38 to onwards, up to 60, I could not produce any lease deed. But rent receipt is there.
38.
Yes, 38. RS record, your Lordship kindly come.
1338.
Yes, your Lordship, it will be better. Your Lordship kindly come page 10 or 40. CS record, your Lordship kindly 140. Yes. Before that, may be permitted to see the documents, mail, it will be better.
Whatever this.
Now, your Lordship kindly come page 95.
Page 90?
95. It will be better. This is my lord the Kobuliyod. It was 9. In the list of names, I have stated everything. এই তো দিয়েছি ও হ্যাঁ দিয়ে দিচ্ছি তোমাকে দিয়ে দেবো একটা দিয়ে দে আমি তো পরে দিচ্ছি আরে দে না তুমি
So Mukherjee, memorize it and give it to him.
আজ তো শেষ হবে না
Some bribe.
No, we know that.
That's
Definitely.
Actually, this case has a long history. That is a.
Yes.
Now, your Lordship kindly see first line Kosso Ijara Kobuliyod. Ijara is there. On the basis of that, I have executed a Kobuliyod. That is in the year of 1903, corresponding to Bengali year, my lord, 1306 BS. And rent was fixed, my lord, rupees 152. March 1903. And these are the, my lord, the schedule of land. Now, your Lordship kindly come page 105. Suit was filed for, my lord, the suit was filed, degree is there. উচ্ছেদ মতে তাতে খাস দখল প্রার্থনা 107, that is the decree is what dismissed.
Not dismissed.
Yes, it was dismissed as non maintainable.
Not maintainable.
Maintainable, yes.
Why not maintainable?
Was because the suit was filed on under section 106 of the BT Act. 106, my lord, speaks about the rent. It is
Wrong caption.
That is why, my lord, it was dismissed.
No, but it was said the proper course for the plaintiff is to bring a civil suit. This was a civil suit.
Civil suit, yes.
See the last finding, page 105, the last sentence.
Yes.
Last sentence. Last.
Should be dismissed
As not maintainable, as not
The
maintainable.
next sentence.
Cost to the defendant.
No, page 105.
105 last line.
Oh, yes.
Last line.
Defendant contended
Last
suit.
last line.
The proper course of the plaintiff is to bring civil suit. Yes.
It was a civil suit. What sort of a suit was this?
Actually, section 105 of the BT Act speaks otherwise.
Okay, that's why. Yes.
That is 100, section 55 of the with regard, it deals, my lord, with regard to the rent. So that is why it was not maintainable.
But under section, as
Five.
per section 89 speaks about
About the eviction.
but that has to be before a civil court only.
Civil court only. But it has not been done.
Anyway, so what
Anyway.
happened after this?
Now, degree is there, your lordship kindly see.
Yes.
Degree is there, 107. Degree is there. Now, your lordship kindly come.
After this, no eviction suit was filed.
No, nothing. That is a specific finding all the authorities that no eviction suit, nothing of the sort. Your lordship kindly remark. Now, my lord, the private respondent during the, my lord, when the BT Act was in operation, they filed, my lord, a return acknowledging us as a riot in respect of this property 110. Your lordship kindly see. Riot naam Khetra Monde, that is our petition interest. In the top, my lord, it is very vital. In the top, your lordship, that Markandeya Babad, that is my rent 170 1332 BS. These are the things, my lord. Now, my lord, they have acknowledged me as a riot in respect of this property. There is no dispute about it. Now, your lordship kindly come straight away 140.
All are NDC.
Yes.
All are NDC.
কোনটা? না না এগুলো তো ইয়ে রিসিট না, এটা তো বি ফরম্যাট। It is returned submitted by the DTs acknowledging us as a riot in respect of this property on the basis of the rent. Now, your lordship kindly come page 140. That is the CS record.
Yes.
Have you lordship got it, man? Yes. Yes. Yes.
Yes, you got.
Now you are kindly see 104, 140, 140 in the right hand side top. You are kindly see Khajna Barat, Mollikpur Moja, Mot Khajna Babat 170. Well, I am pausing here for a moment. But under the CS record of right, there will be in the record of right, there will be the mentioning about the rent. But in respect of RS and LR, that will not be there. That is it is provided under the section 105 of the BT Act. Now, you are kindly see, Otto Sotter Vivaron Dokolkar, Meadi Ijara Horidas De, that is our petition interest. Sotta Sotter Sreni Vivaron, Moddo Sotta Digari, Meadi. That is, my lord, I have been treated as an intermediary in respect of this property.
Yes.
Now, it is continued up to 1338 BS. 19, it started, my lord, journey was, my lord, from 1903 and it continued up to 1338 BS. Now, my lord, your lordship kindly come. These are the CS record. Now, the vital document is 148. page 142 up to, my lord, 147. This is CS record of right. This same thing is there. Now, my lord, your lordship kindly come 148. This is the, my lord, the rent receipt issued by the landlord. I am reading, my lord. That is very vital document. Mouja. Serial number 3. Have your lordship got it, my lord? Raghubati, Horipal, Chakchandi Nagar, Horipal. My lordship not taking pen, my lord, because letter is very small. Serestar Prajan Nam Sri Krishnadhan De. That is our predecessor interest. Jomir Bivaran Ijara Khajna Babad. That is, my lord, the since 1903 to till date. Now, your lordship kindly come bottom. Khajna Tafsiler Bivaran. My left hand side. San 1361 6 Chaitra Khajna Babad 1361 170. Now 1358 BS to 3060 BS 500 train. But is, my lord, that is for 3 years. 3 years, and next, my lord, the 1360 is 4 years. For 4 years, my lord, the rent was paid to the my immediate, my lord, the landlord.
The period we can't read. What is the period?
Period. First, your lordship kindly see. There are, my lord, the captions are there. Bokea Khajna. Have your lordship got it? Middle portion. Khajna Wasiler Bivaran.
Yes,
Middle.
yes, we are reading it. No, we are seeing the columns.
Yes. Now, your lordship kindly see. San 1358 হইতে 1360. Have your lordship got it?
Yes, yes.
Now, right hand side, left hand side, your lordship kindly come. Current. 1361 6 Chaitra. So, since, my lord, 1358 to 1361, the rent was paid to the, my lord, the landlord. So, my lord, the chapter is closed with regard to the, my lord, BT Act. Next page, your lordship kindly see.
What is the date of this receipt?
My lord,
What is the date of this receipt?
receipt.
Date of the receipt.
Date. Date actually.
You don't find it.
Very old document that is. No, there
Maybe
are
on the stamp, we don't know.
there.
Probably on the stamp, but that's undecipherable.
Now, your lordship kindly come next page 149.
Yes.
It was, my lord, the put to the revenue authority at that point of time. They have seen and accepted. That is, my lord, 6/7/1954. 6 Chaitra, na? Koi?
6/7/19.
54. Wasilet Tarik, na? Koi? Oh, yes. Sorry, my lord. Wasilet Tarik, page 148, your lordship kindly come. Wasilet Tarik, 1361 6 Chaitra. Issue.
That's what we are thinking. I mean, you said it was issued in before
No.
that 1360.
No.
1361, it is issued for a
Issued.
previous period.
My lord, up to
1358 to
up to
1360.
the tenure of the BT Act.
No, up to 1360 it was given.
Yes.
Up to 1360, not 61.
61, that means my Bokia areas and
Yeah,
current. That's
correct.
why my lord, this is the
Yes.
All
Bokeh.
yeah,
Bokia.
That is the-
Halsone
yes.
Halsone to current.
170 and 570 total 608.
Because rent was up to rate of rent was 170.
Yes.
So total about, my lord. So, my lord, it covers 4 years. Now, it was, my lord, accepted by the settlement authority. I have put it down. Now, next page is, my lord, 150. This is also a rent receipt in respect of this property. My lord, this is up to this, my lord, the BT Act covered. আর বলবো নাকি?
You stop here.
Let it be up to BT Act.
After withdrawal,
Then
great.
after your state acquisition,
I- although hearing is commenced, uh, the matter cannot be concluded due to paucity of time. Full stop. Let the same retain its position in the list.
Next Monday.
Tomorrow,
next Monday it will be better.
It will be better.
Wednesday is the Friday. It's a holiday.
Holiday, my lord.
Tomorrow is the
Tomorrow is
assessment matter, my lord.
Yes.
Then Friday.
very good. Be listed next on
Monday.
August 31, 2026.
BTH. My lord, it will appear in the top, my lord.
Parthat matter.
Parthat.
My lord.
No, we are not making any further matters partner.
We are very grateful that your lordship.
I am appearing for the writ petition.
My lord, I am for the state being led by Mr. Nikunj.
We don't have time today.
Target to be যাওয়া।
এই বইটা তো 4:30 হয়। টিউশনটা তো আবার
It will be over in 1 minute.
Yes, ma'am, without jurisdiction, the order passed by the tribunal.
You agree to that?
I am not in this.
You agree to that without jurisdiction?
Yes, well, it is a vested proceedings, my lord, because of the error in choosing the forum, my lord, the LRTT has been application before the LRTT has been filed. Lordship will kindly come to the impugned order. Absolutely, at page 4, the operative two issues are framed considering on the page 4 of the impugned order. Lordship, in the middle portion of the fourth panel, considering the issue number such and such, it appears that there is two proceedings with the land purchased by the applicant already vested unto the state under the operation of law from the offer of indemnity of the sale such and such, when intermediate big Raya's hand opportunity to challenge the such and such by vesting order under provision of 53. The applicant being an illegal, but the observation is standing in the way to approach the correct forum. These are the said vesting in question has no opportunity to challenge those vesting order, retention of such and such. Hence, it is concluded that the application cannot be treated as an appeal, and it ordered consider the issue about setting aside the order of vesting under WBEA Act 1953. Taking into consideration the above two observations, we arrived that final decision of this application being such and such is not maintainable.
You had challenged the order of which authority?
I have challenged the record of right, correction of record of rights has been made by my predecessor.
You have challenged the order of which authority before the tribunal?
Tribunal for the correction
Which
of
authority?
BLR.
Directly challenged before the tribunal. Did not have jurisdiction, so
54
could have been just given a liberty to.
Yes. This observation is absolutely. Thing is this.
The scope of the present petition is innocuous. Full stop. The learned tribunal, while holding that an appeal, while holding that the original application filed before the tribunal by the writ petitioner could not be treated as an appeal, and hence not maintainable, not only dismissed and disposed of the same, but also made the observation that the petitioner is an illegal purchaser, the illegal purchaser of the vested land. Full stop. Next para, learned counsel submits that in view of the tribunal having dismissed the application for lack of jurisdiction on the ground of maintainability, such observation against the petitioner would tantamount to prejudging the issue and was rendered without jurisdiction. First up, upon hearing learned counsel for the petitioner and the state, we find substance in the contention of the petitioner. First up, next para, since the tribunal rightly dismissed the application on the ground of lack of on the ground of maintainability, comma, there was no scope for the tribunal to return any further finding as to the petitioner apostrophe's purchase being legal or illegal. Full stop. Hence, comma, WPL Act 151 of 2026 is disposed of without interfering with the impugned order, but modifying the same to the limited extent that the observation made in the impugned order regarding the petitioner being an illegal purchaser stands expunged. Full stop. Next para. The petitioner, nothing in the present order or the order of the tribunal shall preclude the petitioner from taking out an appropriate challenge against the order of the BL and LRO before the appellate authority uh, in accordance with law. Full stop. We make it clear that the merits of the matter have not been entered into by this court.
Grateful.
প্রথমে affidavit of charge filed today.
Yes, ma'am. That happened. Fine, ma'am. Yes, ma'am.
Yes.
Grateful. Hearings.